Hello, everyone, and welcome back to Uncivil Law, where we learn through the misfortunes of others. As always, I am your host, Uncivil Law, a licensed attorney in Texas, Virginia, and before the United States Supreme Court, and I hope you're having a fantastic day. We are here with the continuing coverage of the impeachment trial of Ken Paxton. Ken Paxton was elected to be the Attorney General of Texas, but is accused of effectively turning over his office to be the personal lawyer of Nate Paul through various deeds. The prosecution in the form of the House managers has rested as of yesterday, and the defense is starting its case today. I did a little recap video earlier this morning where I tried to go through the charges in an obviously somewhat summary way because, trying to just give the highlights, and I've already been called a rhino at least once this morning, so that's fun and exciting for everybody. But the evidence against Ken Paxton as it relates to some of the charges is pretty convincing. Some of the charges, not so much. Some of them are legally deficient. But some of them, yeah. Like, in particular, the interference with the MIDI Foundation, pretty good. Principally coming through MIDI's counsel. He's not a whistleblower. He is not, one of the scorned people. He's a lawyer for MIDI. And he was testifying about how the Attorney General office was interfering with him. We also heard from Brian Kamek, hired specially by the Attorney General to be external counsel, and how he worked directly with, for, and reported directly to the Attorney General, which goes a lot to the Attorney General's knowledge of things, the Attorney General's involvement in things, their accession to things, and stuff like that. So, if you don't like the whistleblowers, we definitely have some external evidence from some other people as it relates to other things. And we also, of course, heard some other testimony that didn't really go anywhere. For example, the idea that Ken Paxton renovated his kitchen using Nate Paul stuff, completely unsupported. There's a stray comment from the Attorney General about involving Nate Paul, but really not much in it. And the kitchen has not, in fact, been renovated. So, we don't have any receipts of any countertops being bought, and the countertop has not, in fact, been replaced. So that charge doesn't really go anywhere, for example. We heard zero evidence, like literally zero, as to Ken Paxton getting Nate Paul to hire his paramour as some sort of constitutional bribe thing. Heard zero evidence from that. So some of the charges completely legally unsupported, but some of them looking better than others. So that is where we're sitting this morning. Nicole said, I heard on news report the prosecution actually accidentally arrested. Is that accurate? Well, it depends on your perspective. They seem to have actually been done, but they didn't give the other side the courtesy of cross, which was kind of rude. And the other side just is like, okay, fine, we don't care. We'll call them back if we want to. We want them back. Like we'll waive cross, and we'll call them back if we want them. And then there was a 3-minute argument about it, which was really stupid. It's like, no, you should have the opportunity for cross. We're all here. The witness shouldn't have to come back. And Busby is like, but you're arrested and we're waiving cross and we'll call them back if we want to. We'll put them on as our own witness. And so there was a 3-minute argument about it, which was really, really stupid. Because it's like, look, this is not ambiguous. He's waived cross. Let's move on. But, not for the first time that Rusty has said things that have, somewhat wasted our time. So it's not that they exactly accidentally arrested, but they spent 3 minutes arguing about it when the other side said they didn't want cross after all. You're right. Whatever. Kat says, is it beyond a reasonable doubt? Well, that depends. That's a little bit in the eye of the beholder as to whether or not you think it's beyond a reasonable doubt or not. That's a little bit in the eye of the beholder. That's the ultimate threshold question. Do you think the evidence convinces you beyond a reasonable doubt or not? Or I suppose another way of phrasing that is, do you have doubts based on reason? Do you have doubts that are actually based on reason as opposed to, pure speculation or wishes? So do you have doubts based on reason? There's a question, right? So at the moment, I don't have any particular the evidence against him is very, very strong as to some of these charges, especially the whistleblower retaliation is very, very strong. And hiring Kamek is very, very strong. So we'll see whether or not they can put reasonable doubts in my mind, but so far not looking really, really promising. They are supposed to convict beyond a reasonable doubt, yes. That is the standard they've set for themselves. So this is both political and quasi-criminal. So, yeah. When did they vote on directed verdict motions? For reasons that are beyond me, all those motions were withdrawn. So we had 3 hours of nothing yesterday. They filed their motions for their directed verdict and then they withdrew them. Don't ask questions. I don't know. Kurt is a textualist bordering on extreme and I'm here for it. That might be the nicest thing anyone said to me today. Hey, Kurt, I didn't see an answer, but do you think the judge is giving more deference to defense objections and prosecution? The judge is a talk show radio host, and his rulings have been inconsistent. So I don't really think that you can, at least in my humble opinion, say that he's favoring the defense or favoring the prosecution, because that would require a level of intent and sophistication I'm not sure is possible. It is a little bit on whatever whim he has that moment. It's more capricious. So, yeah. We don't know every detail of the Senate rules. That's true. We haven't gone over them in utter detail. So yeah, at the moment, I don't really have any particular doubts based on reason. I would say. I can conjure possibilities, but those possibilities are not really supported by testimony or evidence that's been offered. But maybe. We'll see. The news was saying Rusty could be disbarred for a screwed up. Nah, you wouldn't get disbarred for that. Are they still doing motion stuff, or is there going to be a defense case today? I can't possibly answer that question. They spent 3 hours dicking around about God knows what last night, and who knows what's going to happen today. I read the judge is responsible for Rush Limbaugh getting a show. That's my understanding. Yeah, that's my understanding. The judge was responsible for initially putting Rush Limbaugh on the air many, many moons ago. That is my understanding, correct?
All rise. The Court of Impeachment of the Texas Senate is now in session. The Honorable Lieutenant Governor and President of the Senate, Dan Patrick, now presiding.
Morning, everyone. Please bring in the jury. Well, I see the bagpipes are gone, but the crickets are still here.
Cam asked, does having a personality such as Tony Busby help or hurt you in court? Yeah, I think it's everything is context specific. I liked him. I think he's a very, very good lawyer. He's proven that he's also human. He's not just a machine. But I did appreciate that he's a very, very good lawyer.
Senator Hughes, I believe you're doing the prayer this morning.
Judge ordered a TRO in the New Mexico order. Yeah, I saw that last night. Based.
Well, let's go to the Lord in prayer. Heavenly Father, when we consider who you are, the one who has always existed before time, way back into eternity, who always was and always will be. When we consider that you made everything we see, things we cannot see, us, every molecule, every particle of each of us, just because of who you are, we owe you everything. We owe you our lives. And Father, when we consider on top of that all that you've done for us, the gifts that you lavish upon us, that you heap upon us, our very lives, and especially those of us in this country and this state, the special blessings we enjoy of liberty and opportunity and justice, unknown in the history of the world, uniquely given to us here from your hand. We know we each have a responsibility in preserving those things as stewards, each one of us, whatever our role. So, Father, we thank you. Thank you for who you are, for what you've done. We confess our failure to acknowledge you as we ought, to look to you, to humble ourselves before you. And we just thank you for loving us. The ultimate expression of your love for us, that Jesus Christ, God's Son, God himself, would humble himself and come to this earth and take on human form and live that beautiful life, and then pay the penalty for all of our sins on the cross, and then raised from the dead on the third day. We thank you for him. Your word says that since you gave him for us, there's nothing you'll hold back. So, Father, we ask you for wisdom that you've promised to give. We ask you to be honored in these proceedings today by everyone here, whatever their role. Thank you for loving us so much. In Jesus' name we pray. Amen.
Thank you, Senator. You may be seated. Members, can we have a little quiet in the courtroom? Can I have both parties come forward?
Oh God, really? Seriously? We're doing another bench conference? Really? We didn't have enough of them yesterday? For whatever it's worth, they've been rotating senators to offer the prayer. So the senators themselves have been offering the prayer. So for whatever value it has, there you go.
Is the defense ready to call their first witness?
We are, Your Honor.
And who would that be?
Justin Gordon.
Justin Gordon. Justin Gordon, come on down.
Counselor,
You are our
state your
next
name for the record.
contestant.
Of course, Allison Collins.
I always give you the time check. Members, House, you have 2 hours, 34 minutes, and 49 seconds remaining. A respondent, 8 hours, 38 minutes, and no seconds remaining.
2:30, man. 2:30 for the House managers. They are going to burn that. The defense has 8 hours. They're going to run out of cross. I can see it happening. I can see it there's no way they have enough discipline. They are going to run out of time. Ken Paxton to be called to the stand. No cross. Put it on your calendar. It's happening. There's just no way. Rusty said he wanted to just ask a couple quick questions and we were there for the rest of eternity. So that is the basis of my prediction. I think it's reasonably well informed.
Were you here on day one to be sworn in? Yes, sir. I thought so. Please have a seat.
Good morning, Mr. Gordon. How are you today? Could you please turn on your microphone and go ahead and adjust it pretty close? The acoustics in here can be a little difficult.
Is that okay?
Yes, that's much better. Could you please state your name for the court?
My name is Justin Gordon.
And where are you currently employed?
I'm employed in the Open Records Division of the Texas Attorney General's office.
And what is your position there?
I'm the Open Records Division Chief.
How long have you been the chief of the Open Records Division?
I began in 2015 at the beginning of General Paxton's term.
Excuse me, I think you're going to have to speak louder and a little closer, okay?
I began in 2015, in January of 2015.
What does the Open Records Division do?
Our division handles a number of responsibilities regarding the Texas Public Information Act. That includes enforcement and review of public information decision requests. We also provide training for governmental bodies on the Public Information Act.
Okay, I'm going to ask you just to slow down a little bit while you're talking, okay, to help the court reporter out. Can you tell us how many public information ruling requests your division handles a year?
Last year we did over 40,000. In the previous fiscal year we did just under 40,000.
And does your division maintain a record for each ruling request?
Yes, we maintain both an internal record of our ruling requests. We also post all of our letter rulings on our website after they are issued.
Do you recall a request for ruling from the Texas State Securities Board in the fall of 2019 for some records related to Nate Paul?
Yes.
Do you recall if any records were released as a result of that ruling request?
I do not believe any records were released in response to that ruling request.
Do you recall if there was a request for reconsideration of that ruling?
Yes, there was.
How frequently does the Open Records Division receive requests for reconsideration or complaints about a ruling?
That's very common. I don't have an exact number to provide you, but that's something that we see certainly on a monthly basis, if not weekly.
Were you also involved in deciding a request for ruling from DPS, the Department of Public Safety, in the spring of 2020, which we're going to call the big request for ease of reference? Do you recall that one?
Yes, I do.
Was that also related to Nate Paul, if you recall?
It was.
At some point, as one of your duties, as part of your employment, did you make a summary of that file?
I did.
Your Honor, if I may approach the witness.
Yes, you may.
I'm going to approach with what is marked as AG.
Hold on one second. Yes, Senator Whitmire? Okay. Allison, you're going to have to speak louder as well.
Even louder, okay.
That'll do it. That'll do it.
I'm going to approach with what has been marked as AG 205, and it has been pre-admitted.
Okay. Members, do you need for us to review with the court reporter what has already been said? You're okay? Everyone's okay? You do? Okay. Okay, so let's go back to where you began the question on DPS, Senator West. Securities. Okay, let's start over.
No problem. Do you recall receiving a request for ruling from the Texas State Securities Board in fall of 2019 for some records related to Nate Paul?
Yes.
Do you recall if any records were released as a result of ORD's ruling?
No, I do not believe any records were released in that ruling.
Do you recall if there was a request for reconsideration of that ruling?
Yes, there was a request for reconsideration.
How frequently does ORD receive requests for reconsideration or complaints about a ruling?
That's very frequent. I don't have an exact number to provide to you, but it's something that we see, if not on a weekly basis, then certainly monthly, several times a month, we receive reconsiderations.
Do you also recall being involved with a request from DPS in the spring of 2020 related to Nate Paul?
Yes.
Now, we've been calling that the big request to help distinguish them. Will you understand what I'm saying if I call it the big request?
Yes.
Thank you. And at one point, as part of your employment, did you create a summary of this file?
Yes.
Your Honor, I'm going to approach the witness with what has already been admitted as AG 205. Mr. Gordon, do you recognize this document?
I do.
Is it a fair and accurate depiction of the summary that you created for this file?
Yes, it is the summary I provided for the file.
Well, let's talk about it. Let's walk through it together, okay?
Okay.
First, how would you describe this particular request, the big request?
It started off as what I would have characterized as a relatively routine request from the Department of Public Safety. The Department of Public Safety routinely briefs our office on law enforcement matters. They, again, very commonly submit rulings to our office. However, as the ruling was being reviewed, it took a turn procedurally, and then there was a number of procedural irregularities that occurred with the file that made it unique.
And Eric, if you could please pull up AG Exhibit 205 and highlight the first paragraph, please. And Mr. Gordon, I think it's consistent with what you just said that there were procedural issues that made this file unique. Is that correct?
That's correct.
Okay, and when was the request received by your office?
On March 13th.
Okay, and at this point, this is when you're talking about it was very routine?
Correct.
Do you recall what exception DPS was asserting?
They sought to withhold the information under the law enforcement exception. That's Government Code Section 552.108.
Is that, there are generally two types of exceptions under the PIA, is that right?
That's correct. There are two, we characterize them as two separate types of exceptions. There's an exception for confidentiality provisions that we would also call mandatory exceptions. And there's a type of exception that is just a normal exception to disclosure that we would call a permissive exception to disclosure.
And which type is the law enforcement exception?
Section 552.108 is a permissive exception. The governmental body has the option to raise it or not to raise it.
What happens if they do not raise it?
Nothing happens if they do not raise it. We won't address it if they do not raise it.
So if they don't raise it and you don't address it, what's the end result as it relates to the request? Are those records released or are they withheld under the law enforcement exception?
Oh, they would be released. They would not be withheld under the law enforcement exception.
So let's talk about some of the procedural irregularities in this file. I'm now in the second paragraph, Eric, if you could blow that up for the senators. Where did this file first start to take a turn towards the unique?
Where you have it highlighted, I described that.
Excuse me 1 second. I'm very sorry. I'm very understanding with 8 grandchildren and a lot of little ones, but we really can't have a distraction.
I'm sorry, might have to step out. I really apologize, but I don't want to distract the jurors. Very sorry for that.
Apparently there's a baby crying in the chamber, I guess.
May we continue? Thank you. I believe you were about to point out to us where the procedural issue
They kicked the baby out.
File.
Based.
We have a statutory 45-day deadline by which we have to issue all of our rulings. That's from the government code. And as we were approaching that deadline, the DPS submitted a follow-up correspondence to our office explaining that the requested information
Attorney Tom would approve.
Interest of the FBI.
Attorney Tom would approve.
And at that time, they also submitted additional records. So in the initial submission, they only submitted a representative sample, which they are permitted to do. In fact, the PIA requires them to do that if the records are voluminous, and they had done that in the initial submission. However, when they submitted the subsequent submission, they submitted additional documents, not the same representative sample that they had submitted earlier. And the new documents were substantially different than the documents that had been originally submitted and were of a different character. So they
and I'm
had
going to stop you. I think that's a great spot. And just to summarize, so essentially, the original representative sample that DPS sent in did not match with the sample that they later sent to your office in May of 2020. Is that right?
That's correct.
And they sent that second sample at the time that they were notifying the FBI that they might have an interest in the file, in the information being sought by the request?
That's correct.
Is that considered a procedural violation under the Public Information Act?
Yes, governmental bodies are required to submit all of the records that they want a ruling on or a proper representative sample by the 15th business day after receiving the request, which had been substantially before this time period.
So this sample was also late, is that correct?
That's right. That's correct.
What is the consequence for a procedural violation of this nature?
Under the Public Information Act, failure to comply with the procedural requirements in requesting decision from our office results in a presumption that the information is released unless the exception that they're raising constitutes a compelling exception. And our office has concluded that Section 552.108 does not constitute a compelling reason. That's a fancy way of saying that they waive that exception, and they would waive it for the information that they had the procedural violation on.
And that would be all of the information that they provided as the second sample in May of 2020?
Correct. Anything in that representative sample, the second set of documents that was not in the first set.
And is it your understanding that that second set of documents had also been provided to the FBI?
Oh, I'm not sure if they provided that second set of documents to the FBI. I don't remember that.
So this late, was the notice to the FBI also late?
Yes. Governmental bodies, there are procedural requirements and there are also due process requirements in the Public Information Act. And because of those deadlines, there are certain notice requirements. So the only notice requirement in the Act that applies to third parties is in Section 552.305. That section requires governmental bodies to notify third parties if their privacy or proprietary interests are at issue, and that notice is supposed to come within 10 days of receiving the request. Otherwise, there's also the due process element of that notice needs to be made in time for those comments to be received by our office before, in time for us to be aware of them, and also in time for the requester to receive notice.
And in this instance, was the notice given close in time to your statutory deadline to issue a ruling?
Yes, we received it just a couple of weeks before our 10-day deadline or our 45-day deadline.
The second sample of the second set of documents that you were provided by DPS, how were those provided to you? Hard copies on a CD, do you recall?
I don't recall if they were a CD or if they were a hard copy.
Okay, so you sent this, the notice went out to the FBI and you received a copy of it. What happens next?
So at that point, we were kind of up against it with respect to the timelines. You've got the highlights here with respect to the, to kind of what was going on in this file. We had also been notified by the requester in this file that he had filed a lawsuit against DPS in this case, which added a whole nother layer of complexity to it. Because the late notice, because the notice was received so close up against our 45-day deadline, we didn't feel like the third party who was notified, FBI, would have had time to submit comments to our office in time, and so while we were waiting for those comments so that we could receive them and review them from the FBI, we took a 10-day extension on it, and again gave ourselves a 10-day extension, which is permitted under the PIA.
All right, I'm going to ask you just to slow down a little bit, okay? You're doing great. So you extend it for 10 more days. Does the FBI eventually provide your office with comments?
Yes.
And do you know if the FBI also provided the requester with a copy of those comments?
At the time, when we identified the documents, we actually only found the comments because the requester let us know that he had received comments, and so then we went and tracked them down. This is at the beginning of COVID, so our mail intake was kind of thrown off. So when the requester notified that we had received comments, we went and tracked those down. To add another procedural complication to it, at that time the requester notified us that his copy of the comments had been completely redacted. Our copy did not have any redactions on it. It just had a reference that at the end that the version that had been provided to the requester was redacted.
In your honor, if I may approach with what's been marked as House Managers 46 but has not been admitted into evidence yet.
You may approach the witness.
Mr. Gordon, do you recognize the document that I placed in front of you?
I do.
What is it?
This appears to be a copy of our internal ruling file pertaining to the DPS file that we've been discussing.
And does it appear to be a complete and accurate copy of the file?
I'm sorry, I'm just double checking.
Take your time.
Randy says, any thoughts on the Biden impeachment inquiry? My understanding is the speaker just unilaterally declared it, which presents some obvious legal problems.
Yes, it does.
I appreciate your thoroughness.
And
move to admit House Managers 46.
He should
Mr. President,
he should get the House to vote for it.
However, in this document, it contains a copy of the unredacted FBI brief, which not only contains personal identifying information, but a number of sensitive information of the types of operations plans and other sensitive law enforcement information, which Nate Paul had been trying to get for a while. If it comes in, we just ask that it be redacted because that information has not been publicly made available.
And Your Honor, we'll get to that on the next request, but I will represent to this court that that is not the case. As has been discussed by other witnesses, this brief was in fact released publicly.
Okay, so they did not object, and I'll let her go along with her line of questioning, and we'll get back to that issue, but thank you for bringing it up. Go ahead.
Thank you. Eric, if you could pull up towards the back of that Exhibit 46, the Bates number at the bottom is 8803.
Mr. President, I do have to, I'm sorry, before this is shown to the jury, there is personal identifying information
And
that has
sir-
not, may I finish?
Stop not talking over each other.
That has not been released publicly. It may have been released to Nate Paul at General Paxton's direction. However, it has not been made public to the world at large. There's very sensitive law enforcement operation plans, details about search warrants, how investigations are done, and also specific names of individuals that are identified and involved.
Come on up to the bench. Please come up to the bench.
Yes, sir.
The lady lawyer objecting to lady doing direct. Well, that means that she's going to be doing the cross. So as to why, as opposed to Rusty, I don't know. But probably a good thing. So yeah, the lawyer who does the objections is the same lawyer who does the cross. I don't know if it has a formal name in law. What I always called it when we always called it one horse, one rider. For any given witness, one lawyer handles that witness for all purposes. So there you go. It probably has a formal name and a rule somewhere, but I always called it one horse, one rider. So there you go.
The ruling said that this would be public.
Objection time gets charged against objection time. The clock keeps running for standard objections. So when they go to the bench, they seem to pause it. But when they're just like talking at the stand, the clock continues to run. Like soccer, the clock continues to run no matter what happens. So, I still don't know exactly what a rhino is. So like, I don't know exactly what a rhino is. It seems to be used just as a generalized pejorative that means any Republican that votes the way I don't like or something, or maybe any Republican who for any reason opposes another Republican or would vote for this. Is it a rhino because they would vote to impeach Paxton no matter the evidence? Is that what makes someone a rhino? I'm still not exactly sure what a rhino is, except someone I disagree with. Yeah. I know what rhino means, Republican in name only. I just don't know what that means. I know what its acronym is. I just don't know what it means. What does it mean to be a Republican name only? What does that mean? Yeah. Liz Cheney? Yeah, but well, that's an exemplar, but why exactly? What are the defining characteristics? I mean, like, what makes someone a rhino? To say Liz Cheney is a rhino is to say that she's an exemplar of the type, but what are the characteristics? What is it about Liz Cheney that makes her a rhino? Also, strictly speaking, she's not even a Republican in name only because the Republican Party kicked her out. So she's not even a rhino, I guess. So I don't know. Call yourself a Republican, but vote like a Democrat and act like a Democrat. I don't really know that that's even I don't really know that that's true of, yeah, yeah. Rhino is rhetoric, yeah. A rhino that isn't populist or centrist to the point of leaning left on issues that rouses up the base. That's an interesting view. That's an interesting perspective because, I mean, populism... I don't know that that could be said to be a defining characteristic of the Republican Party, except maybe in super recent history. I wouldn't necessarily think that populism is a defining characteristic of the Republican Party in any sort of... I mean, there's obviously strong populism trends, especially in modern Republican politics, but unless we want to say like every Republican until recently was a rhino, I'm not sure that's the answer. Tina Lewis says McCarthy says they're following the rules Pelosi implemented when she brought the second impeachment against Trump, which was done without a vote of Congress. That's why there was no vote from Congress. Yeah, I heard him say that, but that doesn't make any sense, and I object to it on a principle level. I object to that. Like, if Nancy Pelosi was wrong for doing that, it doesn't become right because I'm doing the same thing. Like, if the argument was it's legal, so it's legal for us, then okay. But that wasn't the argument. Like, the Republicans didn't say, at least as far as I remember, their arguments was it was illegal. And like, so are they saying that Nancy, it's like you can't have it both ways. Like it can't be, was Nancy Pelosi acting correctly or not by just declaring it? Right? You kind of have to have, if you're going to be principled about this, right? Was Nancy Pelosi legally correct? Was that a legal thing for her to do? If the answer is yes, then it would apply to McCarthy. If the answer is no, it would also apply to McCarthy. So was Nancy Pelosi legally correct or not? But my understanding was the Republicans thought it was legally improper. Did they change their mind? Kay Bragg says they called Cheney a rhino because she doesn't like Trump, and their voting record was over 90%. Elise Danfeck, in contrast, only voted 60%, but Trump loves her, so not a rhino. Exactly. Calling it illegal sure didn't stop it, but that doesn't matter because it's a question of principle, right? It's what do you think if you don't want to be a hypocrite, right? If, you know, being a hypocrite is saying one thing and doing something else. So it goes to what you believe, not what they believe. So did it stop it? No. But what do you believe? Do you believe it's okay or not? If you don't believe it's okay, but you do it anyway, that's being a hypocrite. That's being unprincipled. So, do you think it's okay or don't you? You know? Ali says, you already said the House makes up their own rules. They can just say something is legal in parliamentary procedure, and it is. Okay. All right, fine. So does McCarthy believe that? If McCarthy believes that, then fine. But what does McCarthy think? Does McCarthy think that Nancy Pelosi was acting legally or not? We're not talking about what I think. We're talking about what McCarthy thinks. Whether it's hypocrisy for him. What are his principles? If he thinks it's illegal, then he can't do it. If he thinks it's legal, then he can. But it would have to be legal both ways. By that argument, both sides are hypocritical, so it cancels out. That isn't even close to true in my view. That is not how principles work. That is a very lame argument in my view. The other side is hypocrites, therefore we get to be hypocrites, is a pretty lame-ass argument. Look how hypocritical the other side is. Look what hypocrites they are. Yeah, but how are you able to call them out on the hypocrisy if you're also hypocrites? That's being hypocritical. You can only call out hypocrisy if you aren't also being hypocritical. Otherwise, you're being hypocritical in your declaration of hypocrisy. You know, this is... Do we believe in principles or not? Like, you know, that's what I think. It's like, do we believe in these principles or not? Like, I try to look for the rule. Right? I'm a rule-based guy. What is the rule? And like, okay, so I want to apply the rule in an even-handed way. Principles don't matter when you lose. Arguably, principles matter more when you lose. Principles matter more when times are tough than when they're easy. Principles, when times are tough, that's when a person's principles are tested to see whether or not they're principles. Arguably, principles matter more when you lose. Because then, like, something else is more important than the principle. Winning is more important than the principle. So your principles aren't what matters. Winning is what matters. So you're not very principled. Because it's not your chief thing. If principles are subordinate, they're not very good principles. Principles are flexible. Principles can be nuanced, but not necessarily flexible. Principles can be nuanced. They can be considered. They can be detailed. They can be complicated. But I'm not sure principles can be flexible. Yeah. $9.99 from Tina Lewis. What Pelosi did was illegal, but no one stopped her. No one. Hypocrisy doesn't matter even more, not even the law. That's part of the reason why there's so much division in this country. Well, I suppose I would say that, you know, the better thing to do is be principled. You know, be the man who's principled in the land of the unprincipled. You know. If you're a biblical guy, you know, Lot was saved because he was clean in the land of Sodom and Gomorrah. He did not allow the situation of Sodom and Gomorrah to corrupt him. At least that's why he was ostensibly saved, because he was pure in the land of the unrighteous. So everyone else is dirty is not really a good excuse to become dirty, I think, was the moral of the story.
Members, take your seats. So we're going to proceed slowly, carefully. You may proceed.
Thank you. Mr. Gordon, as a preliminary matter, if a document is released after a ruling request or a ruling decision, would that be released to a subsequent requester for that same information?
Objection calls for speculation.
No, if it's standard policy, it's not speculation.
Yes, there's a specific section that directly addresses that. Section 552.007 of the Government Code prohibits the governmental bodies from selectively releasing information and provides that if information has been released to one requester, then it would be released to a subsequent requester unless there's a special right of access that applied to the initial requester.
Okay.
Sorry.
All right. Mr.
Okay.
Gordon, repeat your answer. Slow down.
Yes, sir. Yes. There is a specific section of the Public Information Act that addresses that. It is section 552.007. It provides that if information is released to one requester, then it would be released to a subsequent requester. It prohibits the selective release of information to one requester and not to another. So if information has been released by a governmental body, then it would be released to subsequent requesters unless there is a special right of access that only applied to the initial requester. For example, If I ask for my driver's license number and receive it, you wouldn't release my driver's license number to the next person because I have a right of access to that.
Thank you for that explanation. Eric, could you please pull up within House Managers 46 at Bates 8803, which is page 77.
I'll also say this.
that-
Everyone is guilty, so no one is to blame is a really lousy philosophy. You know? You know?
Mr. Gordon, can you
Look
speak up
how
on your
dirty
screen?
everyone is. Therefore,
this
no
appear
one's
to be a
guilty
fair
because
and
everyone's
accurate
dirty. It's a pretty shitty philosophy.
Picture of the redacted brief the FBI provided to Mr. Larson?
That's correct.
And Eric, if you could scroll to the next page, so to 78, go down. Is this showing an entirely redacted page?
Yes.
And does that continue through the majority of this brief?
Yes.
Is this unusual?
Yes.
Can you explain why?
Under the government code, if a third party submits comments to our office objecting to the release of information, they're required to notify the requester and provide the requester with a copy of those comments. They are permitted to redact the comments, but only to the extent that it reveals the information that is requested. In this case, they've redacted the entirety of the brief, including all of the substantive arguments.
And why does that matter?
That matters because the requester was not put on notice about what arguments the governmental body was making and would have been unable to respond to them to our office in order to refute any statements that were made or directly address the statements that were provided by the briefing third party.
Is this another procedural violation of the PIA?
Yes.
So far we've talked about at least 3 procedural violations or irregularities with this file.
Objection
Yes.
leading.
Restate your question. Sustain.
Can you estimate for us how many procedural irregularities we have discussed related to this file so far?
There was the failure to submit the representative sample, or they submitted the documents late. Mm-hmm. The representative sample that they submitted the second time was not indicated that the first representative sample was not actually representative. They did not notify the third party in a timely fashion. And then when the third party briefed us, they substantially redacted their briefing to us. Or I'm sorry, they substantially redacted the copy of the briefing that was provided to the requester.
Are you able to tell us how frequently you work on a file that has 4 different procedural irregularities?
We see a lot of procedural irregularities. These are pretty unique, though, in the way that they came in. Ordinarily, what we see are missed deadlines. So it would be pretty rare that we see 4 completely different procedural violations like this.
And again, what can be the consequence of a procedural irregularity of the nature you've been discussing?
If a governmental body fails to comply with the procedural requirements of the Act, then they would waive their discretionary exceptions.
Meaning that any documents that fell within a discretionary exception would be released?
Objection leading.
Sustain. Rephrase your question.
So what's the consequence of that, of the permissive exceptions being waived?
If a permissive exception is waived, then we would not apply it or review it in the context of those documents. And if that's the only exception that's addressed, then those documents would be released.
And in this particular file, the DPS file in front of you, was the only exception raised the law enforcement exception?
That's correct.
And it is a permissive exception?
That's correct. They did not raise any confidentiality provisions. They only raised the law enforcement exception.
Do you recall meeting with the Attorney General about this file?
Yes.
And I don't want you to go into what anyone said at that meeting, okay? But could you please tell us what topics were discussed?
We discussed this topic, this DPS file.
Did you discuss options for how to proceed?
Yes.
And what were those options?
The primary options were to release the information, to conclude that there had been a procedural violation and a failure to establish that the information was accepted from disclosure. And then the second exception, which was the primary option, was the closed letter that we ended up issuing.
Did you agree with with issuing the closed letter?
Yes.
Why?
It was correct. The procedural background of the request put the requester at a significant disadvantage, and allowing the the procedural actions that were taken would have really been a detriment to that requester. There was already a pending lawsuit, and courts will give our letter rulings great weight, and rubber stamping the actions in this procedural context would have, or could have, I don't know what the court would have done with our ruling, but it could have tilted the scale in favor of a governmental body who had failed to comply with the procedural requirements.
And I want to make sure I understood your testimony a moment ago. You considered releasing all of the information. What do you call that within ORD?
Pouring out.
And would that have been supportable under the law, in your opinion?
It would have been pushing it. I agree with the closed letter. I feel like releasing it all would have been pushing it.
To your knowledge, had ORD issued closed letters of this nature in the past?
Yes.
Eric, I'm going to ask you to pull up the closed letter, which is within House Managers 46 at page 2, and please take it off the screen before finding the new page and placing it there.
Counsel, what was the page number that you directed him to, please?
It's page 2 of the PDF, which is in front of you.
That OAG 8728?
I don't have it in front of me, but it's the closed letter. Mr. Gordon, does this appear to be a complete and accurate copy of the closed letter?
Yes, it does.
And in that letter, you reference a prior ORD decision, right?
That's correct.
Why? Why did you reference that prior ORD decision?
Well, there were a lot of reasons. The primary reason is that what this open records decision specifies is that if a lawsuit is filed after a ruling request is made, I'm sorry, let me take it back and maybe simplify it. Under the Public Information Act, a requester can sue a governmental body if they believe they're improperly withholding documents. What this open records decision provides is that if a requester files a lawsuit after a governmental body has issued or has requested a decision from our office, then our office should still go on and issue a ruling. Prior to this decision, we routinely closed files and did not issue determinations where the issue that come before us in the decision was in court. So we would demur and close that letter and let the court decide.
And in your opinion, how did this DPS file differ from the closed letter that you issued in this case? How did that differ or was distinguished from that ORD decision?
It was all of the procedural irregularities, especially the redacted FBI brief. That was the primary issue that prevented us from ruling in accordance with due process. It was the heavily redacted FBI brief.
And why did that cause you so much heartburn?
Again, our rulings are given weight or great weight, quote unquote, by the courts, and in the face of those procedural irregularities, giving a rubber stamp of approval to them could have tilted the scales in that that court, even despite the procedures being handled incorrectly.
Could it also set bad precedent?
Objection leading.
I'm asking his opinion, Your Honor. It's a yes or no. He can say what he'd like.
Overruled.
I'm sorry, I didn't understand. I didn't hear the question.
Sure. Could it
Good
also
answer.
set bad precedent in PIA
Good answer.
requests
Just because it calls for a
coming
yes or
into
no
office?
doesn't necessarily make it
Objection, Your
leading.
Honor. The relevance of this
Right,
personal,
leading suggests
witness's
the
opinion
answer.
is not relevant to any issue.
So if the
in this
answer is
proceeding.
open,
And what he considers
even if it's
a good or
limited, it's
bad
not
precedent
necessarily
is
leading.
purely
So,
subjective
good
and
response.
not at issue in this case.
Your Honor,
Overruled.
thank you. You can answer the question.
I wouldn't characterize it as a precedent. So many of our rulings are fact specific. What I do think it could have resulted in, because DPS and FBI routinely brief our office, it could have again been seen as condoning that type of heavy redaction, which then could have led to that type of action being taken in future requests and for future requesters. So I wouldn't have characterized it as a precedent, but it could have indicated that we thought that was okay, and then they would, because they do it routinely, they request decisions from us routinely, they could have seen that as oh well, now we've got the stamp of approval to do this, and now we'll keep doing it.
And now, while all of this is going on, were you made aware of a request from Mr. Larson for a copy of the FBI brief?
Yes.
How were you made aware of that?
That came in as a Public Information Act request. The Public Information Act request was forwarded to my division for handling. And when I say handling, I mean we collected the documents. So we collected the unredacted brief in processing that Public Information Act request, and we provided it to our Public Information Office.
As to the DPS ruling itself, did that closed letter result in the release of any documents?
It did not.
Okay, so this request from Mr. Larson comes in for a copy of the brief. Do you know what happened after that was received?
I know what happened after the fact. Because it involved open records decision documents, our division does not rule on decision requests for our own documents, so it was handled by another division. But through the process of this whole circumstance, I did become aware of what issued or what happened with that public information request.
And your division maintains those files even if it doesn't necessarily make the decision on the request, correct?
Dave asked, can the
That's correct.
questioner's tone affect
Because
whether
the
it's
FBI
true or
submitted
false?
the brief
It's
to our
considered
office.
leading. Yes.
We were the ones who
certainly.
maintained that as part of our work file.
Certainly, yeah. The tone can be suggestive of
Have
the
you
answer depending
reviewed
on how it's asked.
the
Yes.
ORD file for the FBI brief request before?
So
It's one of the
just
reasons,
to
incidentally,
clarify,
that
our office or my division
judges
does not
are given
have
so much weight
a file on that public information
appeals
request. We have the file that's
because
here
they have the
before me
benefit
as this
of seeing
PDF,
the
and yes, I have
parties
reviewed
and
that.
hearing them and hearing
But I have not
exactly
seen
how they
the,
said things,
I have
which
not
of
seen
course
the
is not going to be
opinions
reflected
file
on the
or
transcript.
the public
Observing their
information office
behavior,
file involving that,
assessing their
that ruling
credibility.
request for that brief.
So there's
Now, in
things that are not going to be on
file
the
in front of
record
you,
when it goes
there
to
is a
appeal.
copy of the unredacted
So that's one of the
FBI
reasons
brief, correct?
trial judges are given so much discretion, because they see things that the Court of Appeals can't see.
Would you take a look at it, please?
Not that that fact is particularly relevant here because there's no appeal, but, just as a generalized principle, as long as we can learn something of value. So, not applicable here because there's no appeal. This trial judges God, but, that's, normally how it goes.
Okay, I'm looking at page.
And what I want you to look for, you're the chief of ORD. I want you to set aside law enforcement exception for a moment. I want you to look at that brief and let me know if you think there are any mandatory
Or more to the point, the
exceptions
jury
to
is
public
God, because technically
disclosure
speaking, the
that
jury
are
can overrule the
flagged
judge,
within
which is
that
also
brief.
hilarious because of the way this thing is working. Jury is best judge because jury overruled judge, because that's a thing we can do in this case. Political trials, man. Political trials are weird. What's my opinion on removing courtroom cameras from Kohberger's case? I would oppose it. I feel like there's less dramatic steps that could be taken, and I would be inclined to take less dramatic steps than removing the cameras from the courtroom. I would be disinclined to take such a dramatic step unless other steps had failed.
Not to nitpick, but there is Mr. Larson's email address is at the end of the brief, but he was the requester. So no, but other than that, I don't see any confidential information on the face of the document.
Thank you. And just one more thing on, forgive me. Your Honor, if I may approach with what's been marked as AG 34.
You may.
Are we talking about circumstantial evidence with respect to Kohberger? I don't know what they have. And they haven't made it particularly public,
do you
which is
recognize
fine.
the document I placed in front of you?
You know?
I do.
And what is it?
The evidence available is not sufficient to convict, but I don't know what they have.
For the opinions ruling request that we've been discussing, that was Mr. Larson's request for the unredacted FBI brief.
Does OAG
I think it's premature to draw conclusions about
for copies of PIA
Kohberger.
briefing on other occasions?
Yes.
Does that occur can you tell us with any sort of frequency how often you receive that type of request for briefing?
If I had to guess, I'd say it would be once a month, probably less than once a month. It's not very common. It's not a weekly occurrence.
And were you familiar with Joe Larson?
Yes.
How?
I've worked with Joe Larson for a long time. He is a well-known open government lawyer. He's also involved with the Freedom of Information Foundation, which our office has partnered with in the past to perform trainings. He's routinely sought after to provide input on Public Information Act requests. I've also observed a number of cases that he's handled because he ends up often handling important Public Information Act cases.
Uncivil, they ask, punctuated equilibrium asks, In and Out, Whataburger, Shake Shack, or Five Guys? The people deserve to know.
Was it surprising or unusual for him to
All right,
submit a
so
request
between the four, Whataburger is going to be
No,
last
I wasn't
place.
surprised at all that Mr. Larson would ask
What you
that.
know, hot take, but
And
you
started
asked.
to walk us through what OAG does when it receives a request for documents that OAG itself holds.
I think next
just wanna
I'll
make
do
sure that's
Shake
for the
Shack
jurors,
in
okay?
order.
So let's walk through it.
And then between In and Out and Five Guys.
What would do when it receives a request for records that it itself holds?
Five Guys is probably a better experience
That would be received and
overall,
handled by
although In and Out is very good in its own
Public
right. So
Information
I think I'll
Office.
go.
The Public
Objection, Your Honor.
I think I'll go Five Guys,
But at
In and
this
Out,
point,
Shake
it's clear
Shack,
from the witness's own
Whataburger.
testimony that once this request that's about to be discussed was made, it went to a different division, not his, that he does not oversee, and he's previously testified that he was not involved. So any information that he has about specifically how it was handled or by whom would be hearsay or speculation.
Your Honor, right now I'm asking him to walk through the general process of how this is handled, which is something
Five
that as the chief of
Guys
OAG
is too
intimately
pricey.
familiar with.
I would agree. Although you
The witness
get
can answer
all the
overruled.
fries ever. So that's nice.
When a request
and you get
comes
free
into our
peanuts,
Public
which is also
Information
nice.
Office, the
But
Public
yeah, Five
Information
Guys is too
Officer will
pricey.
identify the divisions
But for sheer quality
they
of the
believe
experience,
maintain
Five Guys
documents,
over
and they will
In and Out.
notify those divisions. Those divisions then
If you're factoring
collect the
cost into
information.
it, then
generally we collect the information unless
pretty
there's some
close
issue with the
between
request,
Five
like we
Guys
don't
and
understand
In and Out.
it, or it would require
I think it's going to
a
be
cost
kind of mood
estimate.
dependent. In and Out might
Those
squeak ahead on
divisions,
that
my
one if you're
division in that
factoring
case,
cost into it.
will respond back that we maintain documents, and then we'll follow that up by providing those documents. If a decision is required, then the public information officer will prepare that decision, and they will send it to our division. As soon as we see that we've received a request from the Attorney General's office,
Cookout is pretty good. Cookout is pretty good. I haven't had a Cookout burger in a long time. That's a North Carolina-based company.
Not deciding decisions.
They've been expanding
on
though,
documents held by
so
ORD, is that right?
but yeah, I've had good experiences at Cookout Burger.
Sustained. You can re-ask the question.
I think the point's been made, Your Honor. I'm going to move to admit AG 34. It is an internal business record of OAG. It was actually given to us pursuant to a business affidavit that has been on record for more than 14 days.
And Your
Any
Honor,
objection?
as we discussed at the bench, the issue is not the business records affidavit. It is protecting the sensitive information of law enforcement, how they conduct their investigations, and specifically the individuals involved.
Cookout also has the
Identical
best
copy
selection of
the same
milkshakes
brief
in
we
the
just
game.
talked to you about at the bench.
I forget how
is
many
also
they have, but they got
contained
like
in this
30
document.
different
And
flavors
so
of
I have no
milkshake.
objections as long as she's
So if the
willing to
milkshake bring all the
protect
boys
law
to the yard,
enforcement
Cookout
and the
Burger is
integrity of
definitely
their
for you.
investigations and redact that sensitive information. With those redactions, no objection.
And Your Honor, the chief of ORD has now looked at this brief and told you that there were no mandatory exceptions and no confidential information within that brief. He's also testified that once documents are given to one requester, they are given to any subsequent requester. They are considered public. And so I do believe that he is very highly qualified to speak to this file, and that there are no confidentiality concerns raised within it based on this witness's testimony.
Brief response, Your Honor.
Yes.
Everything my colleague said misses the point. All I'm trying to do is make sure that the sensitive law enforcement information, which is in front of you, the identities of the individuals involved in the investigation, how they conducted the investigation, their sensitive operations plans, their sealed search warrant affidavits, and the details contained within, how they communicate with each other, who was on those communications,
Casino
when they were sent,
Casino El Camino
all of that
in Austin on
information I just
6th,
would ask
their burgers are
would be
fantastic.
redacted.
And Your
Otherwise-
Honor,
Yeah,
very
I agree completely
Don't talk over each other.
with that
Public
comment,
order is a
Rogue
tough
County.
job.
Casino El Camino's burgers, Austin on 6th Street, their burgers are fantastic. Great. Fantastic burgers. Could not agree more. The burgers are bae at Casino El Camino on 6th. Yeah. Yeah, Cookout has expanded throughout all the South. Yes, for sure. They're North Carolina based, which, yeah, they've expanded throughout the South. They're expanding quite a lot. I think I mentioned that. They may be coming to a town near you. Worcestershire sauce on your burger? Yeah, that I like to put Worcestershire sauce in my ground mix when I'm making them at home. Worcestershire sauce and mustard powder are two of my secret ingredients in my burger. So, now you know. Bojangles is fantastic for chicken. Yeah, Bojangles for chicken is fire. Zaxby's is overrated, though. There's perhaps a hot take for some Southerners in the chat. Zaxby's chicken, overrated. As long as we're making friends and enemies over here, you know? Cane's is okay. Cane's is good. Cane's is okay. There's no Bojangles. Raising Cane's is better than Zaxby's. I'll agree to that. Evil Coleslaw says Chick-fil-A is basic. Okay, that's a hot take for sure. Bojangles does fried turkey at Thanksgiving? Badass. I didn't know that. Thank you, Dragon, for noticing the my face. That's really appreciated. That's great. Thanks. My efforts at concealer are apparently being noticed on camera. So, concealer fail. Yeah. Fuddruckers makes a good burger. I remember thinking very highly of their nachos. It's been a while since I've been to a Fuddruckers. I just put on a little spot concealer today. I didn't put on makeup all over, which maybe it was a mistake, because I got a little green tint basically on one side of my face but not the other. So probably should have put on some powdered concealer that was green so my overall face color was more matched. So the spot concealer without doing stuff to the rest of the face may have been a mistake. These are makeup lessons we learn the hard way over here at Uncivil Law. I have already decreased the saturation of red inside the camera. And I don't want to decrease it anymore, because if I decrease it anymore in camera, it looks weird. But I've already decreased the saturation of red inside camera, which says something about my face. So, yeah. Sonic is good for hot dogs. Their Conies and their All-American hot dogs are very good. And also they make a good breakfast burrito. It's very enjoyable. And their shakes are very good too. Sonic is a pretty good overall experience. Here's a potentially hot take. Arby's is underrated. A lot of people like to shit on Arby's. But at least in my experience, I think Arby's gets a bit of a bad rap. I think Arby's is underrated. There's a hot take for you. Will I be covering Murdaugh Trial 2.0? Well, if the clerk of court winds up in trial, we'll cover that. Speaking of which, should we read more of her book? Let's read some more of her book while we're waiting for whatever it is they are doing over here in the Texas Senate. We are, again, continuing our book read together of the Colton County Clerk of Court, who wrote a book about her experience reading the verdict in the Murdaugh trial. Her job is to stand up and read the verdict. And she wrote a book because she has main character energy. And we are continuing with our coverage, which we will pick up in the middle of wherever we were last time. So we will continue with the middle of this. And it is absolutely a candidate for the Nobel Prize for Literature. I mean, how could it be anything else? And you will just see the words truly just leap off the page. She writes, for example, one juror started her monthly cycle, and I asked my executive administrative assistant, Polly Riley, to go get some products for the juror. Polly was already one step ahead of me and said, wait a minute, I already have what you need tucked away for such a time as this. Polly saved the day. Another challenge we faced was having two different jurors who received traffic tickets.
Take a break in a little bit, just a little bit. Everybody be seated, please.
I was looking forward to reading more. All we got was the paragraph about the monthly cycle.
Going through this testimony, slowly continue.
Mr. Gordon, the file placed in front of you marked as AG 34. Is there any search warrant inside this file?
There is no search warrant inside this file.
Are there any emails between the FBI and DPS inside this file?
There are no emails between the FBI and DPS in this file.
Did you notice any victim information inside this file?
I did not.
And if the redacted FBI brief had been released to one requester, it would be released to other requesters?
That's correct.
And you've had a chance to look at this file now, correct?
Yes.
And at the back of it, you'll see that, well, let's walk through it. So I think you've testified that based on this file before you, does it appear that OAG sent a notice to the FBI about this request for their redacted version of a brief?
Yes, it does.
Did the FBI respond?
Yes, they did.
And I want you to take a close look at their response brief, and specifically the last page under the signature line. It's the last page of the file. Are you there?
Yes, that's page 6 of the draft.
Witness needs to stay close to the mic and speak up.
Does it indicate that the version sent to Mr. Larson was redacted?
Objection, Your Honor. The counsel is mischaracterizing the evidence and honestly misleading the witness. The document that she
Overruled.
is...
You may answer the question.
On this brief, it does not say redacted after the CC list to Mr. Larson.
And this brief was filed by a Mr. McPhillips from the FBI, is that right?
That's correct.
And from the front of this brief, was it filed, and it's actually marked as received by Open Records on or about June 18th, 2020? Do you see that?
Yes.
And then I want you to look immediately in front of this brief is a copy of the redacted brief at issue. Do you see that?
I'm sorry, would you repeat the question?
Yeah, if you keep flipping forward in the file, the next thing you see is a copy of the blacked out brief that the FBI had filed first.
Oh, I believe that's, I don't see in this.
The Bates at the bottom of the page I'd like to direct you to is 49982.
49982. Oh, yes, okay. That's the last page of the redacted version?
It's the last page of the brief that the FBI filed in May of 2020, right?
That's correct. I'm sorry, I was looking for the version that was actually redacted. There's no redacted version.
I apologize. There is no redacted version in here. And when you look under the signature, first, who signed this brief from May 2020 for the FBI?
Matthew Phillips.
So the same Mr.
Nick Phillips?
McPhillips?
Yes.
And underneath his signature line, what does it indicate next to Mr. Larson's signature? I mean, next to Mr. Larson's name on the copy list?
Next to Mr. Larson's name on the copy list, it says it was redacted.
So the first brief was sent to Mr. Larson, redacted. Is that what that represents to you?
Yes.
And so the second brief, the June 2021, based on the documents before you, was that redacted when it was sent to Mr. Larson?
It does not indicate that it was redacted.
Does that indicate to you that the FBI provided a copy of this brief directly to Mr. Larson?
Objection leading.
Sustain, rephrase your question.
What does that indicate to you?
That indicates that they provided the same copy of this brief that they provided to DPS, not unredacted.
And I want you to take a look at this June 2020 brief and tell me how it compares to the May 2020 brief.
They look very similar. There is some different language certainly at the beginning, but they look very similar.
Other than the first paragraph, they are very similar.
Yes, that's correct.
So based on the documents in this file, does it appear that Mr. Larson that the FBI provided this information itself to Mr. Larson?
Yes.
And the very front of this file is the decision issued in this case. It starts with Bates 49954. Do you see that?
I do.
And you just looked at the FBI's June 2020 brief addressing whether or not that blacked out brief should be released to the public, right? You just looked at it?
I did.
Did it anywhere in there argue that their redacted brief should be withheld from public disclosure?
No, it looked like the arguments applied to the documents that were issued in the underlying DPS file.
And so when that happens, when the comments don't address the information being sought, what, in your experience in ORD, happens in a file like that?
In that case, we would not apply the exception to the documents that are submitted. We ordinarily, because this opinion was done by opinions, they use slightly different language than us, but we've got boilerplate for that type of circumstance. Either that the entity that submitted the arguments is arguing against the release of information that was not submitted to our office, or that the arguments that they've submitted don't apply to the information that is at issue. Because we have a presumption of openness, there has to be an exception to disclosure in order to withhold the information. And if it's a discretionary exception, it wouldn't be applied to information that they don't seek to withhold. If it's a discretionary exception, they have to seek to withhold it in order for the exception to be applied to it.
And the FBI, so the FBI just didn't address their redacted brief at all, based on this file, is that right?
That's right.
Which would result in what, ultimately, for the requester?
That would result in the information, that would result in the arguments that are raised not being addressed to the information for which there are no arguments. And if there are no other arguments, then the information would be released.
Okay, so I want to make sure we all understand what your testimony has been here today. So we had the first request to TSSB in the fall of 2019. Was any information disclosed to Nate Paul as a result of OAG's ruling?
No.
Then we move on to the big request to DPS in the spring of 2020. Was any information released to Nate Paul as a result of that ruling?
No.
And then we get to this third request. And what we see is that the FBI provided a copy of the brief directly to the requester itself. Is that right?
Objection leading.
Overruled. Repeat the question and answer.
We get to this FBI request for their blacked out brief. And what we see is that the FBI directly gives a copy of the brief to the requester, to Nate Paul. Is that correct?
Objection, Your Honor. It should be made clear for the record that we are talking about two different briefs, one in May and one in June. And the one in June, yes, there's no dispute. The FBI provided that to Nate Paul's counsel. That is not the one that contains the sensitive information that we have been discussing.
Clarify.
Of course.
I sustain the objection. Clarify.
What we're seeing from this file is that the FBI provided a copy of its June 2020 brief directly to Mr. Larson. Is that right?
Yes, that's correct.
And you've also testified that that June 2020 brief is very similar to the May 2020 redacted brief, right?
Yes, that is correct.
And that ultimately, because the FBI did not address why their redacted brief should not be released to the public, it was released.
Objection leading.
Sustain. Rephrase your question.
What was the ultimate outcome of the opinion on this FBI request related to its redacted brief?
The opinion concluded that the unredacted brief could be released to the requester.
And you reviewed that brief?
Yes.
And you did not see any mandatory exceptions within that brief that would require OAG to apply its own redactions before release?
That's
Objection
correct.
leading.
Overruled.
That's correct.
And after this ruling in August of 2020 on the FBI brief, do you recall one way or another if Joe Larson, on behalf of Nate Paul, continued to seek information from public safety agencies through public information requests?
Yes, he did.
And how do you know that?
He continued to pursue complaints against the Texas State Securities Board all the way through September of that year, seeking to obtain documents that TSSB was withholding from him in the context of Public Information Act requests. So then that continued, throughout the summer and into the fall.
And after ORD rules on a request, what does ORD do with the documents that the governmental agency provided to you to make your ruling?
We send the documents back to the governmental body.
You don't keep a copy?
No.
Those are all my questions for this time. Thank you.
Thank you, Ms. Collins.
Examination, Your Honor.
Yes.
I'm so sorry. One thing, we are moving for admission of HM 46 and AG 34 based on this witness's testimony.
Your Honor, same objection. All we're trying to do is protect the sensitive law enforcement operations, who was involved, when emails were sent, what the subject of those emails were, what the FBI's operations plans were, how they work with the State Securities Board, the FBI, the DPS. If that information can be redacted, no objection.
Hold on. We've discussed this at length. He testified there was nothing confidential. The FBI could be here. They could be called.
Yes, yes, Your Honor, or Mr. President, yes, that's correct.
Either one, doesn't matter.
Okay, yes, sir.
But they're not here.
They're not, however, I would like to, for the record, remind the court that it was Mr. Bangard's testimony opposite to Mr. Gordon's.
Your Honor, I'm going to insist that she not say testimony of another witness in front of this witness.
Okay. Both of you, just stop for a moment, okay?
Your Honor, if I could, I just want to make sure that there's no misunderstanding or misstatement here.
Jurors, please take your seats again.
I just want to make sure that there's no misunderstanding here, that you have a complete copy of those files in front of you, and you can see for yourself that there are no copies of search warrants, there are no copies of the actual emails within those files, which appear to be the documents that counsel is concerned about, and I just want to make sure that's clear for the record, that those documents are not in those files.
And we have reviewed them while up here, going through this testimony. Is it your representation as an officer of the court that this document has already been released to the public?
Yes.
Both documents?
Yes.
And that was the testimony?
It was.
I have to overrule your objection. We'll admit into evidence. AG 34 and OAG Exhibit 46.
That should be HM 46 and AG 34,
Oh, I'm sorry.
Your Honor.
HM 46, yes.
Thank you, Your Honor. Those are my questions for now.
Yes. You're a witness.
Good afternoon, morning, Mr. Gordon.
Please state your name for the record, for the...
Leah Graham. You talked about this decision being fact-specific. Do you recall that testimony?
Yes.
So let's talk facts. The requester in this case was Nate Paul's lawyer, correct?
Objection, speculation.
I believe that same testimony was elicited on direct that Joseph
Overruled,
Larson.
go ahead.
Correct?
We did not know that at the time. It's become apparent that that is the case now, but we did not know that at the time.
In your original opinion, as it relates to the request for the full release of the DPS file, was that it should not be released and that the law enforcement exception applied. True?
That's the big DPS file that we're referring to?
Yes, sir.
The original draft on that, I believe, did just address it under the law enforcement exception.
And that was your opinion that it should not be disclosed under the law enforcement exception, correct?
No, that was not my opinion. That was just the first draft that was on the ruling.
Who drafted the first draft?
I'm not sure if that was the drafter on the ruling or if that was me. I don't remember.
You had direct conversations with Ken Paxton about this specific request for a full copy of the DPS file, true?
Yes.
He made it clear to you that he wanted to find a way to release the documents that Nate Paul's attorney was requesting, true?
Objection, Your Honor. That's improper testimony through this counsel, assuming facts that have not been addressed with this witness.
Your Honor, this testimony has already been elicited.
Overruled.
True?
No.
Mr. Paxton did not summon you to his office to talk about this file?
Yes, he did.
He did not put pressure on you to either not rule against the requester or to release the information?
No, I would not classify it as pressure. The decision that we made was not.
Sir, I appreciate that. I'm not asking you what the decision was made. I was asking about your conversation with Mr. Paxton. He had one of two things that he wanted to occur. Either release the information or at a minimum, figure out a way not to rule against the requester. True?
Same objection, Your Honor, assuming facts not before this witness.
Sustained.
In your conversation with Ken Paxton about this particular DPS file, can you recall any other time when Mr. Paxton directly came to you and got involved on a DPS open records request?
No.
Ultimately, you did exactly what Mr. Paxton wanted, correct? You did not rule against the requester, Nate Paul's attorney, true?
Again, objection, Your Honor, assuming facts not before this witness.
Overruled.
True?
I'm sorry, could you repeat the question?
Yes, sir. Ultimately, the opinion was not to rule against the requester, which was exactly what Ken Paxton was pressuring you to do, correct?
Again, Your Honor, I'm going to object. She's now mischaracterizing this witness's testimony. He said he was not pressured.
Sustained.
By not ruling, you were not ruling against the requester. By making a no decision, that's not ruling against the requester, true?
That's correct. We didn't rule against either party, the requester or the governmental bodies at issue.
Now, earlier you said that the OAG decision not ruling against Nate Paul's attorney, quote, tilted the scale in terms of how a court would ultimately decide whether or not to rule on the disclosure of that information. True?
No, if I said that, I may have misspoken. We did not want to tilt the scale. We didn't want to tip the scale either way. We wanted to maintain the status quo and allow the court to review it completely de novo without our opinion, which is due great weight, tilting the scale based on the procedural requirements.
Withholding the information would have been detrimental to the requester. That's what you said on direct. Do you remember that?
I'm sorry, could you repeat the question?
You said withholding the requested information would have been detrimental to the requester. Do you recall that testimony?
I'm going to object, Your Honor. I don't recall that testimony either, so mischaracterization of his testimony.
And I'm happy to put her on the stand. I'm asking the witness if he recalls his testimony.
We can check with the court reporter.
I have a quote, it would have been detrimental to the requester.
Okay. I'm going to overrule. You can answer yes or no.
Yes, it would have concluded that the information could be withheld.
Now, on June 8th, after the opinion came out, Joanna Ward, do you know who that is?
John Award?
Yes, sir.
Yes.
Okay. On
Yeah,
June 8th,
Matt Harris
she
was saying this in
if
chat.
You still had the file in your possession. Do you recall that?
Are you saying as an officer of the court gets my attention real fast?
The entire DPS file, correct?
Real fast.
Yes.
And within that file is one part of it would have been the probable
If
cause
you ask me,
affidavit that
if the
Nate Paul
judge
was looking
were to
for.
ask me, are you making this representation
I
as an
believe
officer of the
that,
court?
if I'm not
sure I
mistaken,
could
think that
confirm
was
my
after
own
the
name.
ruling had been issued.
It is.
Well, you
sir,
better
that's
be
not my
real
question.
sure.
Included within the DPS
You better be
file
real
would have
sure.
been the probable cause affidavit that Nate Paul was looking for. True?
No.
The probable cause affidavit would not have been within the DPS file.
Not after we issued the ruling, we would have sent the documents back to DPS.
But by June 8th, after the decision was released, do you recall Joanna Ward emailing you and specifically asking you if you still had it, it was still checked out to you, and asking when you were going to return it? Do you recall that?
Yes.
We talked a lot about precedent and what should be publicly disclosed. You would agree with me that a search
That is a
warrant
big
is
flashing
treated substantially
sign.
differently
Are
than a
you
probable
sure
cause
you
affidavit or
want to
search warrant
do
affidavit
this?
in terms of
Are
whether or
you
not that should be
really,
released
really
to the public,
sure?
correct?
There are different exceptions that can apply to those, but I would not characterize anything as what can or should be released to the public. It needs to have an exception
Big flashing
that applies
sign.
to it. But both can be released to the public. A search warrant affidavit is more likely to have an exception that applies. They're not automatically confidential.
Correct. No further questions, Your Honor.
Redirect.
Very briefly, in any of these requests, could either party have filed a lawsuit challenging the outcome?
Yes.
Did anyone file a lawsuit for the outcome of the FBI brief ruling request?
No.
That's all I have, Your Honor.
And just so the court knows, because it has been unusual, either side can ask questions from the podium or their tables in case anyone's asking. Can the witness,
Requires no redirect, Your Honor.
pardon?
Witness requires no redirect. Recross.
Can the witness be excused?
Yes, Your Honor. Thank you, Mr. Gordon.
Am I released, Mr. President?
I'm checking with the House. Yes, you can be released. Thank you. And so we'll call their next, no, we're going to take a break. Sorry. We'll call your next witness after a break. How about 5 minutes after 10? 20-minute break?
5 minutes after 11?
11. Sorry. We passed the 10 hour. 5 minutes after 11.
All right, so we're taking a 20-minute break so we can talk. So yeah, so this was all dealing with whether or not there was personal identifying information or sources and methods from the FBI in their investigation in this document. Are you about to expose someone's personally identifiable information or sources and methods? Which, you know, is kind of a big deal. You know, it's like, you want to think about that one a little bit, maybe. And so she's saying, okay, this is already in the public, so there's nothing to be exposed. This is already in the public. And so the judge is like, are you sure this is already in the public? Are you sure this is already public information? And so we're not exposing it now. And she's like, yep, I'm sure. Okay. So, if you're wrong, you just exposed someone's personally identifiable information and or sources and methods of the FBI or some other law enforcement apparatus. And you did it in explicit contrast to your own representation. So, yeah, that's kind of a big deal. Right? I mean, because you're making this affirmative representation, this is already public, so there's no harm, no foul. Right? This is completely separate, incidentally, from whether or not being private, we should expose it now. Right? That's a separate question. So if it's private, should we expose it now? Is a separate argument. But it's already in public, so there's nothing for Your Honor to worry about. That would get my attention right quick. It's like, you better be sure. It's like, it's basically, do you want to put your ass on the line, counselor? Are you sure? Do you want to put your ass on the line? Because opposing counsel is out here telling you this is still secret information. Do you really want to put your own ass on the line? And like, yeah, if a judge asked me, what time is it as an officer of the court, I don't know that I'd do it. Because like, yeah, I'm not about to make that kind of representation. It's like, I don't know. Ask clock. I don't know what time it is. Who am I? Where am I? Am I a lawyer? Not sure. Did you pass the bar? As an officer of the court, are you sure you passed the bar? I don't know that I can make that representation, Your Honor, because, yeah, I don't, who am I? Where am I? We're all in a fantasy world. Yeah. General Turgonaut says, what's my take on the governor of New Mexico issuing the emergency? Roughly the same take as the Attorney General of New Mexico and the district judge who ruled against it. It's blatantly unconstitutional for so many reasons. And if I were issuing the decision, the first line of my decision would read something like, a claim to emergency is the first refuge of the tyrant. Oh, it's just an emergency. Surely, this time only, just for this reason. It is the first refuge of the tyrant. I definitely have a snarky line like that as the first line of my opinion, and it would get worse from there. So yeah. Yeah. She didn't flinch, so she better be real sure. Real sure. The New Mexico governor's order was laughable on its face. I mean, not for nothing, but it literally is not an emergency because it's not emergent. It is not something that has suddenly sprung up to life. The problem that she's saying is that there is a problem of gun violence, but that problem is not emergent. It didn't just happen this morning. So how can it be an emergency when it's not emergent? These and other good questions are raised by Uncivil Law. You know, we didn't just wake up this morning and suddenly, oh my, there's a sudden spat of gun violence. There was no gun violence before. We just woke up this morning and whoa, gun violence. It's emergent. Well, geez, we better take actions because of the emergency. You know, tornadoes are emergent. Hurricanes are emergent. This is not emergent. It is not an emergency. It offends me. I like words, and I like that words have meaning, and they mean things. What she said, there's this magic button called emergency. If I push the magic button, I can do anything I want. Never mind, it's not an emergency. Magic button. She abused the magic button. It offends me. Alan Parker gifted 20 gift memberships. Tina Lewis said McCarthy about the Pelosi thing we were discussing earlier. Kay Bragg gave $10 to say they called Cheney a rhino because she doesn't like Trump, even though her voting record was over 90%. Matthew Felly said an article of impeachment does not exist for Biden, an impeachment inquiry does. Well, whether or not it legally exists is a whole other set of problems, and it would be better to get the House to vote on it. So, to solve the problem. I don't know, can McCarthy not get the votes to get an impeachment inquiry going? Does he not have the votes? So, and if he doesn't have the votes for the inquiry, like, what hope is there for anything else? So maybe he should do some more politicking. Tina Lewis commented about the whole Pelosi discussion we had. Kay Bragg said, I'm no true Texan for saying Whataburger is last. Whataburger sucks, at least in my experience. Tina Lewis said her book may cause a retrial for Murdaugh. Yep. I think retrial possibilities for Murdaugh are looking real good right about now. And those were the super chats we had. She even said, which was even stupider, she even said, criminals won't follow the order. Only law-abiding people will follow the order, which makes it even stupider. So the order is not even broadly tailored to the emergency. So it doesn't even meet rational basis review is how stupid it is. I mean, it's pretty hard to fail rational basis review, but the governor of New Mexico is trying real hard to fail rational basis review. Because she admits that her own order won't stop the criminals who are the problem. So her own order doesn't do anything to solve the emergency. So it doesn't pass rational basis review. Forget strict scrutiny. Forget intermediate scrutiny. It doesn't even pass rational basis. That's how dumb it is. It's pretty hard to fuck up rational basis, and she's doing a really good job at it. I mean, there's no relationship between the emergency and the order. She basically admits the order does nothing to solve or treat the emergency. So what are you doing? Ruger said the dumbest thing she said that the Constitution is not absolute. No, I don't necessarily object to that in and of itself, but I object to the conclusion. Right, I object to this is the thing that I see, especially my friends on the left do. They say, okay, like the First Amendment is not absolute, or the Second Amendment is not absolute, which, okay, fine. Depending on how you understand that phrase, like I'll concede it. I'd phrase it differently. But, you know, for the purposes of the exercise, I'll allow the rhetorical phrasing. You know, I'd give you a better, more precise phrasing of a similar concept. So I won't begrudge you too much on the First Amendment's not absolute, the Second Amendment's not absolute. What really, you know, grinds my gears is basically because it is not absolute, therefore my thing is necessarily legal, which doesn't follow. That's a really dumb conclusion. Right? Because it's not absolute, my thing is necessarily legal is a really, really dumb conclusion. But they do it every time. It's not absolute apparently means I can do anything I want. And it definitely doesn't mean that. So, yeah. $2 from David says I'll get no super chat from him. That's very sad for me. I really wish you would super chat me, David. Her oath is not absolute, might be even stupider. Because I'm not even sure what the hell that means. Even in principle. Like, I you know, in trying to desperately give the New Mexico governor, you know, trying to rephrase what she said into not stupid, I'm not even sure what my own oath is not absolute means, even in like a charitable rephrase. Like, what is the what she really meant was this, and I'm not sure what that is. So, yeah. Yeah, I'm not 100% sure what that means, even in principle. I am. Yeah, so I don't even know what that means. They take the 14th really, really seriously? Oh, you mean with like Section 3? Trying to disqualify Trump? Yeah, maybe. The second is absolute. It depends a little bit what you mean when you say it. Like, you have to be careful, right? And this is sort of like what I've said before. And this is incidentally, like we've talked about this before many times, but the first thing you have to do is define the right to keep and bear arms. That's the tricky part. And we've talked about this before, and it's the same thing when it comes to the freedom of speech or the freedom of religion or any of the freedoms, right? The word "the" is a definite article referring to a specific antecedent. It's a specific thing. So before you can even talk about what infringing the Second Amendment could even theoretically be, you first have to define the boundaries of what the right is. So saying it's absolute or not doesn't really help you very much, because you first need to define what the thing is that is absolute. So even if you conclude it's absolute, you first have to define what the thing is that is absolute. And that's where things get trickier. And the Supreme Court correctly, in my view, in Bruin, said the correct test is the historical analysis, which is incidentally exactly what you do in the First Amendment domain. So, like, what is the freedom of speech? You understand it by understanding its historical basis. So, like, if you were asking me, for example, like another lawyer might say, for example, defamation is an exception to the First Amendment. but I'd phrase it a little bit differently. I'd say defamation is not within the First Amendment at all. It's just not there. So it's not an exception to the First Amendment. It's just not contemplated by the First Amendment. So I'd phrase it a little bit differently, but that's me. Are there writings that back up the Second Amendment from when it's written? Surely, of course there are. Yeah, I mean, there's plenty of history throughout the history. You know, we were yesterday reading a case from like the 14th century just because it was fun. There's plenty of case law, plenty of writings, plenty of history to be done about what the Second Amendment was understood to mean. So, like, yeah, there's plenty of stuff to talk about. The Second Amendment also, for its own case, went through a couple drafts. I wrote a paper on it in law school where I went through all the different drafts of the Second Amendment. So that gives you a pretty good idea. Plus, of course, all the debates that were held in all the legislatures that were ratifying the Constitution, plus the statements, you know, by the people that proposed it and their writings and their all this stuff. Like, yeah, you can have a pretty good idea, like, collectively what they thought they were talking about. Plus the historical analogs from all the cases in England, UK. Sure, plenty of stuff. Maybe it's like saying that defamation is not part of the First Amendment at all is a little bit like saying that a statement against interests isn't hearsay at all, which they love to trip you on the bar. Like, they love to trip you on it on the federal rules of evidence. It's like one of their favorite questions, because a statement against interest isn't a hearsay exception. It's not hearsay at all. They love to trip you up on that on the bar exam. So yeah, for me, defamation isn't a First Amendment exception. It's just not the First Amendment at all. So it's a way of looking at the problem. So to understand the Second Amendment, you need to understand its contours. And I think for me, although it's not necessarily I think for me, like, they had it basically essentially correct in Heller and McDonald, that, you know, it's the weapons that are in sort of ordinary and common use is what the Second Amendment is talking about. And that makes sense from its historical analog, because, and this is also like reflected in the Militia Act, that says that every adult male who's between the ages of 17 and 45, which also includes me, is part of the unorganized militia. So, and the Second Amendment, of course, talks about a well-regulated militia, and so the militia is the everyman and the person. And so, you know, what the Militia Act flat out says for that matter is that every person is supposed to bring their own arms with them when the militia is called. So the militia, being the people who are just, you know, in their day-to-day life, farmers or whatever, are bringing the arms that they have familiarity with, because it's the weapons they have on hand and they have some familiarity with. So the Second Amendment appears to contemplate the kind of weapons that a person might have ordinary common familiarity with, because it's the weapons they would bring to the battlefield that they would then be in a position to use because they would understand their use, that they don't have to necessarily be trained on from ground principles, because it's something that they would use in sort of their ordinary domestic life, if you like. So, you know, pistols, shotguns, and rifles would fall into that category, particularly in a historical context, where those weapons would be used for everyday normal purposes, like, you know, getting your own game so that you can eat and stuff. or, you know, protecting yourself, you know, in the frontier and stuff. So like that seems to be what the Second Amendment seems to really be contemplating, is weapons that people would have occasion to use and have some familiarity with in normal everyday domestic life. You know, that's what the militia would bring to bear as the church bell rings to call them to service. So that seems to be the thrust of the Second Amendment to my mind. And then when you talk about like cannons and other things beyond that, then I'd have to read a little bit more. My knowledge of the case law isn't as sharp as it used to be, and I don't mind admitting to you there was a time and place when Uncivil like knew everything, and some of that knowledge has escaped from his brain. So when you start talking about like cannons and warships and things beyond that, that's where I'd have to like go back and sort of like think about it, you know, more. But it would at least include, you know, pistols, rifles, and shotguns, because that would be the kind of thing that you would expect the person pressed into militia service to bring with them. You know, probably don't expect them to bring a cannon with them. Obviously, there was some private ownership, but whether that is contemplated by the Second Amendment, I'd have to actually go and, like, you know, do the research. So, you know, that's sort of where I think about it. Yeah. And Wim says most of the warships and artilleries in the War of 1812 and even a number of Civil War were privately owned. Yeah, that's true. That's true. But whether or not that's the degree to which that speaks to the right of the everyman is still a little bit I'd have to actually do research on it and actually think about it. Right? The right by its nature is individual. And so it has to be an arm that an individual, it seems like it would have to necessarily be an arm that an individual could use and make ready and use. So I don't think, for example, it could really realistically include a warship, because no individual could effectively use a warship personally, and the right is personal in its nature. As to a cannon, like, that's also like questionable for similar reasons. But again, I'd have to like look into it in sort of a deep dive originalist sense to try to see, you know, what the historical understanding is. But that's how you'd go about it, right? That's how you go about understanding the Second Amendment. You'd understand, you know, it's an individual personalized right. It's a fundamental right. It belongs to each person individually. The nature of the weapons that are kept and bear thus also are individualized in their nature, because it's an individual right. So it has to be, to some degree, it has to be something that an individual could use, I think. But that's sort of my thoughts on the thing. And you know, the degree to which there were people that had cannons or warships or whatever in private use is something I'm a little bit vague on in the historical analysis. And it also, was that really what they were contemplating when they were talking about this individual right? Because I think that was probably an exception rather than the norm. And but again, I'd have to look at it, you know, and try to really understand it from first principles. Punctuated Equilibrium says, just like the First Amendment, mole people can combine the two-way rights, so crew service weapons would be in. Well, in the First Amendment domain, the rights are individual. And I don't know that there is any First Amendment collective right or First Amendment collective thing. People can gather in collections to exercise their rights, but I'm not aware of any First Amendment right that can only be exercised by the collective. An individual, at least in principle, could do anything that is a protected First Amendment right. So I'm not sure there's any right that emerges from the collective nature of it. Except, I suppose, for the freedom of assembly, which necessarily implies multiple people, but then again, it's explicitly in the text that it's multiple people, so that example doesn't really work. The freedom of the petition. Petitions aren't necessarily collective, no. Petitions are not fundamentally collective in their nature. A individual can petition for the redress of their grievances. Petitions are not fundamentally collective. So the individual has the freedom to petition. A bunch of people can also petition in a similar way or the same way, because they're each individually exercising their own individual right. So the nature of the petition is fundamental. The fact that a whole bunch of people are individually doing it and doing it in the same way doesn't change the nature of it. The right to petition is fundamentally individual. Individual and collective are not protected in the Bill of Rights. The individual is. The collective, only to the extent that they are. In the nature of the collective is the nature of the individual. I'm not sure there's any collective aspect to the First Amendment beyond like the freedom of assembly, which necessarily implies multiple people, but then again, it's in the text. So I'm not sure there's any collective aspects that emerge. The collective's rights in the First Amendment are only there because each individual has them. I'm not sure there's any right in the collective as such. Can I talk about whether corporations are people with individual rights? Well, corporations are persons. Well, here's how I would answer the question. Let me answer the question the way I would answer the question. How about that? A corporation is by its nature a collection of people that have gathered together for a collective purpose. We, very long ago, established the idea of corporate personhood. In fact, the entire nature of corporations is corporate personhood. Corporate personhood goes down as far down as you like into the very essence of what corporations are. That's what corporations are, fundamentally. It is a corporate personhood. The entire point of the corporate form was corporate personhood. The idea that the corporation could, as an entity, like buy things, own things, do things. So corporate personhood isn't a novel concept. Corporate personhood goes right down to the foundations of what corporations are. The entire point was to separate individuals away from the corporate form. So there's that. Does a corporation have freedom of speech? The individuals do. So the corporation inherits the freedom of speech, if you like, from the people that make up the corporation. I mean, on some level, a corporation can't do anything without people. Corporations can't do things. Only people can do things. So I would say that a corporation's freedom of speech is emergent or derivative from their individual members acting in concert. And so I would say that that's how I would answer the question. So I don't know if that answers your question, but that's how I'd go about answering the question. The corporation only has rights because the people that are in them have rights. And the corporation only has power because the people inside them have power. The actions of the corporation are emergent from and derived from the people that make them up. So that's sort of how I'd approach the question. A surety bond? A surety bond just means a bond that's backed up by surety, which is to say an asset. A surety is just an asset. It's assurance. It's a backed bond. Am I familiar with American state nationalist soft sit stuff? Only to the extent that all soft sits drive me absolutely crazy. Beyond that, I don't know about any specific faction or flavor of them. They're all stupid.
The next witness is Austin Kinghorn.
Bailiff, please bring in Mr. Kinghorn.
And Your Honor, I'd just like to, while Mr. Kinghorn's coming in, I just want to clarify for the record, for the jury, and for the public. At the end of the day yesterday, we had called Professor Michael Gerhardt, who's intended to be one of our expert witnesses. Last night, the court ruled that the expert testimony we were going to provide would not be heard. And so to the extent there was confusion, I just want to make the jurors aware and the public aware that that was the court's ruling, and that's why those witnesses aren't here.
And the court ruling was based on objection from the House under rule such and such.
Yeah.
Rule such and such.
About an hour
that's
to
a new rule.
deliberate and look at all the questions.
That's right. I apologize for,
We ruled in favor of the House on that.
Just wanted the public to be aware, that's right.
And you were very kind to pull them from your witness list.
Soft sits drive me crazy. They drive me absolutely insane. If I ever become a judge, I'm going to have a sign outside my courtroom, and I'll get on the exact wording. But the thrust of it will be, you breathe soft sit, you will be held in contempt.
Mr. Kinghorn, I believe I already swore you in the group.
I'm not messing around with this shit.
Speak loudly and closely to the mic. Thank you.
So someone can help me work on the exact wording, but you breathe soft sit in my courtroom.
Austin, good morning. Thank you for being here. We both need to speak slowly and loudly into the microphone. I am told you've testified in this chamber before the Senate, correct?
Yes, I have.
Okay, so you know the acoustics in here can get a bit weird, especially for our folks in the back.
That's correct.
So please just introduce yourself to the jury and tell us about your career.
My name is Austin Kinghorn. I'm the Associate Deputy Attorney General for Legal Counsel at the Office of the Attorney General. Would you like me to go back from the...
Yeah, sure. Why don't, if you could please just start with law school, walk us through what you've done up to the present day.
So I graduated from Baylor Law School in 2010. After that, I did a clerkship on the 14th Court of Appeals for then Justice Jeff Brown. I did a stint in commercial litigation. Yes, sir. I did a stint in commercial litigation after that, primarily doing insurance defense. After that, I went to work for the AG's office in the Civil Medicaid Fraud Division. When Justice Brown was elevated to the Texas Supreme Court, I went to work for him again as a staff attorney. I worked at the court for about 6.5 years in that capacity for Justices Brown and later Justice Jane Bland. And then came back to the AG's office in the General Counsel Division. From there, I was promoted to General Counsel, and then most recently to the title that I hold now.
Thank you, sir. And tell us a little bit about your work for the Attorney General and your current roles, both as General Counsel, Opinions Committee, and your current title.
Right. So as the Associate Deputy for Legal Counsel, I'm over 2 divisions. It's a General Counsel Division and the Opinion Committee. In that role, I am both the Division Chief of General Counsel and General Counsel for the agency, and also Chair of the Opinion Committee.
How many employees do you oversee?
19.
And are you proud of your time at the Attorney General's office?
I am very proud.
I think this is a bit of a silly question, but it's come up a lot. Are you a rhino? Do you know what a rhino is?
Yes, I do. I've been called a lot of 4-letter words. That's not one of them.
Cute.
What are your politics? Are you conservative?
Yes, I am.
Again, I think it's a silly question, but it's being asked. On a scale of 1 to 10, how conservative do you think you are?
11.
Fair enough. What I'd like to do today with you is go through these articles of impeachment, see if there's any perspective you can provide as to each. And I appreciate you being here helping explain the work of the agency for the jury. So let's start with Article 1, which relates to the Mitty Foundation and the intervention into that lawsuit. Were you directly involved in that lawsuit or that intervention in any way?
I was not.
Okay. But are you familiar with EAMs?
Yes, I am.
Unfortunately, we've talked a lot about EAMs during this trial. What's your understanding? What is an EAM to you?
An executive approval memorandum is a document that the agency relies on to seek and attain executive approval of various agency actions or engagements.
And do you receive EAMs as part of your work?
I do. I probably receive one or more a day.
What do you do if you have concerns about an EAM?
If I have concerns about an EAM, typically the practice is going to be to reach out to who circulated the EAM and, engage with that person directly, try to flesh out the issues. Sometimes it's simply a matter of correcting something in the EAM and recirculating it. So, the first step is always just get in touch with the folks who are asking for the executive action and connect and make sure you have an understanding of what's going on.
If you get an EAM that you're concerned about or you're proposed a course of action that you don't agree with, do you just go ahead and sign the EAM anyway?
No, I do not.
Okay. So what does signing the EAM signify?
That would signify
it signifies that I'm supposed to set condition 1 SQ
the explanation
and order
of
people to missile
rationale for
stations.
the action that's being sought, and that you approve of that action being taken.
Different
So
EAM?
if someone at the Attorney General's office signs an EAM, does that mean they've approved that action?
That's correct.
What about, let me ask you this. Does the Attorney General have to have an EAM that's fully approved by his subordinates before he takes an action?
No, he does not.
Why not?
The Attorney General's authority and the First Assistance Authority flow directly from the Texas Constitution and from statutes, specifically Government Code Chapter 402. The EAM process exists to vet certain proposals, but it is ultimately not binding on the person or persons who actually possess the constitutional executive power to act as Attorney General or on behalf of the Office of the Attorney General.
So just to make that clear, the Attorney General has the legal authority to act without an EAM approved by his subordinates?
Absolutely.
Okay. Does that include the authority to sign a contract?
Yes, it would.
Okay. Let's look at an example of an EAM. Can we pull up House Exhibit 62, please, Mr. Arroyo? Your Honor, I believe this has already been admitted into evidence, and I'm going to try and go electronic today, so we'll see if it works. And Mr. Arroyo, if you could just zoom in on the signatures on the top of this EAM and maybe capture the subject line as well.
My Navy joke apparently did not get the chuckles from the chat I was hoping for.
Have you seen this EAM before, Mr. Kinghorn?
Oh, well.
Yes, I have.
Okay. And which EAM is this?
This is a EAM requesting approval to intervene in the Mitty Foundation litigation.
You weren't a signatory on this EAM, correct?
No, I was not.
Okay. But let's look at the first signatory. That's Mary Henderson. Who is that?
Mary Henderson at the time was in our financial litigation division, and she held a senior attorney role in that division.
And what does her signature on this EAM indicate?
That would indicate that she has
what Navy
approved
joke? When he said, "What's an EAM?" and I said, "Oh, what does an EAM mean?"
This EAM.
And I said, it means I should order condition 1 SQ and send people to missile stations.
It's from Mary
That was
Henderson,
the Navy joke?
and also she's the first signatory. So
Is this
typically
thing
the
on?
first signatory on the
Bueller?
document, the lowest
Bueller?
signatory would be the person who actually routed the document for approval.
So does this indicate that Mary Henderson and Kat Day actually authored this EAM? Is that what this says to you?
That's likely the case, yeah.
Do you know whether the Attorney General ever spoke with Mary Henderson or Kat Day about this EAM?
I do not know.
Okay. Who's next on the signature line? Who's Josh Godby?
Josh Godby at the time was the division chief for the financial litigation division.
And what does his signature here indicate?
That
One
would
MC is
also,
broken. Yeah,
indicate
there you go.
approval
Yeah,
of
one
the
MC is
action
not
that the
working.
EAM is seeking.
And who's next up the chain on this EAM?
Yeah. Oh well.
It's Darren McCarty.
What was his role at this time?
All right. So
He was the Deputy
in
Attorney
Navy
General for Civil
parlance, an
Litigation,
EAM
so
would be an
you see his
emergency
name
action message.
A lot on EAMs like this involving.
It is typically an order that you would get that would
And again, I
indicate
want to
a
be
missile
clear about what
drill
his
or
signature
other
means
action.
here.
So
when he docu-signed this EAM,
emergency action message.
what does that indicate to you
in
as General Counsel
in
of the
Navy
agency?
submarine parlance,
That
they talk
indicates
about
approval of the
situation.
action
They
that
talk
is
about the
sought by the
status
EAM.
quo. They talk about status
Same
quo.
question with
So it's
Mr.
called
Mateer.
SQ
What was his
for status
role and
quo.
what is his signature
So
here
condition
indicate
1
to you?
SQ is the highest level of alert for a Navy
Jeff
sub.
Mateer was the first
So
Assistant
ordering
Attorney
condition
General
1
at the
SQ
time,
is ordering
and,
condition
his
1
signature would indicate
status quo.
approval of the action that EAM.
Ordering people to battle stations missile
would
to
it be
prepare
your
for a missile
expectation
launch
that
or
all of
missile
these
drill.
people who signed
That's the
this
joke.
EAM,
I've now
have
dissected
read
the
it?
joke.
It would. I mean, that is certainly the point.
That's what you normally do within OAG, right?
Correct.
And would it be your expectation that they understood the memorandum before they signed it?
I would not sign an EAM that I did not
Objection,
fully
Your Honor.
understand.
Question calls for speculation.
I'll move on. Thank you, Mr. Roy.
Sustained and.
All right, let's move on to talking about Article 2. That's about the foreclosure guidance letter. It's been called a lot of things in this courtroom. That's what I'm going to call it. Do you understand what I'm referring to? Are you familiar with that letter?
I do understand and I am familiar with it.
Okay. Did you work on that guidance letter personally?
In a very limited capacity early on, I performed some very perfunctory research on it. I never participated in the drafting of the letter itself.
Who asked you to do that research?
Ryan Vassar.
And did you form a conclusion as to what was the ultimate outcome in your limited role?
As memory serves, I didn't form any firm conclusions at the time. I performed a couple hours, maybe 3 hours of research, and really just had enough time to kind of come up with some general parameters of what the issues were. And Mr. Vassar and I had a phone conversation about what we had found so far in our respective research, and he took it from there, and I never had another conversation with anyone else about the letter moving forward.
Did you see the letter once it was ultimately issued?
Only when it was issued, yeah, when it went up on the website.
Right, so to be clear, you weren't involved in the drafting process, so you don't know how they got from A to Z on that.
That's right.
Okay, but you saw the final letter.
I did.
Did you agree with the analysis and the conclusion in that letter?
I do.
Objection, Your Honor. Relevance.
Overruled.
And just as you sit there today, can you briefly explain what that letter does in your view?
All my jokes relate to the single
let me
integrated
rephrase.
operational plan.
Can you explain the conclusion?
I only
of the
tell
letter?
PSYOP jokes.
The legal conclusion?
Yes.
It's a very specialized form of comedy.
Essentially was that under the circumstances of COVID at the time, with 10-person restrictions on in-person gatherings, that there was a possibility that a public sale, as defined by statute, that necessary element to proceed on a foreclosure wouldn't be satisfied if you didn't have a situation where anyone who wanted to be a bidder on a property that was under foreclosure would have an opportunity to bid on it and thus get the most fair value for the property.
Let me make sure I understand each piece of that. So you mentioned the public sale issue. That's a requirement out of statute. Did I understand you?
That's right.
Okay. And you mentioned a bidder being excluded. Why would that be the case?
Sorry, could you repeat that?
I thought you mentioned the 10-person requirement might result in a bidder not being able to participate in a foreclosure sale. Why would that be the case?
Correct. So normally these sales are open to the public. Anyone who wants to go bid on a property can, and that of course has the effect of increasing the price typically. And the COVID restrictions are at the time, the governor's executive orders only permitted 10 people to gather at once in what was considering, I think the nomenclature was at the time, a public gathering.
So to make sure I understand what you're saying, if there were bidders that were excluded, that could drive the price down at the sale?
Yeah, that's certainly a possibility.
Okay. In your view, does that letter shut down foreclosure sales in the state of Texas?
I don't have an opinion on whether it did or didn't. I do know it was non-binding and informal legal guidance.
Did you work on any other COVID-related opinions or guidance documents?
I worked on a great number of them. During my first several months at the agency, starting in June of 2020, COVID-related work was the vast majority of what I was doing.
And if you could just briefly for a minute here, explain to the jury, explain to the public, we're trying to explain the work of the Office of the Attorney General today, so explain what it was like to be working on these issues during COVID.
It was intense. It was a demanding time, as I'm sure it was for a lot of people in this room. We were on the cutting edge of a lot of novel legal issues. A lot of folks were looking to the AG's office for guidance and direction on how to respond, how to navigate the challenges that were coming forward, especially as it pertained to the governor's executive orders, which were coming out. We were often looked to for guidance on how to comply with those, what they meant, construing them, and we fielded those requests from all corners.
Was it unusual during that time to have expedited requests or to be working on short deadlines?
That is never unusual at the OAG, under any circumstances.
Particularly so during COVID?
Sure, particularly so.
Just call me Dropkick. I have a message for Skybird.
With a problem,
testing.
It wanted an answer, at least quickly.
Understood. Let's talk about opinions and guidance documents from the Attorney General's office.
Where are my missileers at in the chat?
What kinds of guidance can the Attorney General issue?
Well, there's a range of options. A lot of folks in this room are probably familiar with our formal legal opinions. Under Chapter 402 of the Government Code, a authorized statutory requester may request a formal legal opinion from the OAG, and that opinion, while not binding, is a source of persuasive legal authority that courts typically will look to and consider when resolving a case. But we have other tools in our belt beyond that. Additionally, under Chapter...
Before we go to the next one, I just want to clarify one thing. You mentioned that a lot of folks in this room might be familiar with that formal legal opinion. Why would that be the case? Why would these senators and some of these House members be familiar with that?
Chairs of legislative committees, senators and House members, are authorized requesters under the statute.
Okay. Does the Attorney General's office work frequently with those authorized requesters regarding their requests for opinions?
We frequently work with members of the legislature on a host of issues and try to be as solicitous as possible in being helpful and giving the best legal guidance we can.
And I'm sorry I interrupted you. So that was the formal legal opinion process. You're moving on to the next category, so I apologize for interrupting.
Sure. So under
one of my favorite bits of stand-up was when Robin
Code,
Williams,
which is the Texas Disaster
was addressing that.
The AG's
I
office
think it was
has
Army,
additional authority to provide legal counsel to local political subdivisions.
And so they,
during a declared
the
disaster.
trumpets came on, and
authorized requests
the entire audience
county
turned
judges,
around,
county
faced the
commissioners,
flag.
emergency management directors.
Everyone turned
beyond
around
that,
8 degrees to face the flag.
The office has
Ron Williams told a spoof
operated
joke about it. It was
with
pretty
understanding
good.
that we have broad legal authority with the Attorney General.
Never had that happen before. Never had an entire audience just say, "Forget you."
Guidance of public note, of public interest that would have a wide applicability.
We're all going to turn that way.
To the public at large, especially in disaster situations where there's a need to get good information out to the public on pressing issues. And that authority, I think, flows directly from the Attorney General's constitutional and statutory authority as the Attorney General, as the Chief Legal Officer of the state.
Other than the foreclosure guidance letter, can you recall any examples of other COVID-related guidance that was issued that also fell in that third category you described?
We put several guidance documents out on issues that a lot of folks are facing. Churches, private religious schools. I know that we did some opinions on access to vacation homes, and not opinions, letters on access to vacation homes in other states, where golf courses fell in terms of the governor's orders for shutdown purposes. So there were a lot of topics that we put something out there short of a formal opinion that was designed to provide generally applicable informal legal guidance to the public at large.
So it's fair to say, is it fair to say that the foreclosure letter was not unique in that regard? It was not the only informal guidance that was put out?
That's correct.
Let's look at a couple of other examples of guidance from this time. Mr. Arroyo, if you could pull up House Exhibit 105. And I believe this has already been admitted, Your Honor. Are you familiar with this document, Mr. Kinghorn?
Yes, I am.
And just very briefly, what is this document?
Objection, Mr. President. This document is not in evidence.
I apologize. I thought it had been admitted. It's House Manager's Exhibit 105, and I'd offer it if it hasn't been admitted.
We thought it was pre-admitted, Ms. Epley?
No, Mr. President, I don't believe so. We don't object. It's our document to begin with. I just wanted to make sure the record was clear.
Yeah, I apologize. I tried to get this smoothed out with counsel before we started, but yes, I offer it, if it hasn't already been admitted.
Okay. It will now be admitted into evidence. That's exhibit, what's the number, 105?
House Exhibit 105, Your Honor.
Okay. Admit it to evidence.
Mr. Kinghorn, if you could, please just, if to the extent that you can, please just describe briefly what this document is.
This was a general guidance document that the agency issued to houses of worship during the COVID pandemic.
Is this a full-blown opinion under Chapter 402?
It is not.
And is this a disaster council letter under Chapter 418?
No, this is not.
Mr. Arroyo, if you could show us the bottom of the page, there's a date next to the exhibit stamp. And when was this letter issued?
It says April 27th of 2020.
Do you think it was any way improper for the agency to issue this guidance?
No, I do not. And in fact, I think this is the kind of guidance a lot of folks were looking to the Attorney General to provide.
Let's look at another example.
May I seek clarification? He was confirming that the guidance in regards to the house of worship exhibit 105 is not something he takes issue with, correct? Not the foreclosure letter itself?
Your Honor, she can cross-examine the witness.
No, I'm clarifying.
This is my examination,
Yes.
and she should be able to.
You can cross-examine on that.
Okay, thank you.
Thank you, Your Honor. Let's briefly look at House Exhibit 104 next. I also thought this one had been pre-admitted. Maybe I'm wrong. To the extent that it wasn't, I'd offer House Exhibit 104.
Matt, you here? You want to be a reference for me for a job I'm looking for?
Thumbs up.
Do you want to say nice things about me if asked?
Mr. Kinghorn, have you seen this letter? Or rather, are you familiar with this letter?
Yes, generally speaking, yes.
Okay. This is a letter in response to Chairman Frank?
Yes, this is the one about the golf courses. Okay, I had to read a little bit into it.
Okay, great. Let's look at the last page, please, Mr. Arroyo. If you could just zoom in on that text, please. So this letter, was this a full-blown Chapter 402 opinion?
No, it was not.
And how can you tell that?
It's got some language there caveating that it is not a formal opinion issued pursuant to Section 402.042, which is our formal opinion statute.
It says on the letter that it is not a formal opinion under Chapter 402.
That's right.
So if someone were to say that this was a Chapter 402 opinion, they would be wrong. Do you agree?
I do.
Are you aware that the foreclosure guidance letter has substantially similar language in it?
Yes, I am aware of that.
Okay. And who was this letter signed by?
Ryan Vassar.
So Ryan Vassar signed an informal guidance letter.
Yes.
Does that indicate to you whether Mr. Vassar thought he had the authority to sign that letter? Do you think there was an issue with authority for issuing this letter?
I assume that he operated under authority to issue this letter on behalf of the agency.
Did you think a requester was necessary for the foreclosure letter?
No, I did not, personally.
Do you have any personal knowledge as to why one was sought?
I do not.
So you'd have no reason to disagree with me if I were to tell you that a requester was demanded because someone was trying to get out of doing the
Objection,
work.
Mr. President, I'm sorry. Counselors testifying to facts not known to this witness.
Sustained.
You can take that down, Mr. Royal. I think that's enough for Article 2. I think we're going to skip Articles 3 and 4 because I don't think you have any unique responsibility with regard to the PIA. Is that true?
I do not, that's right.
And we've heard plenty about the PIA today. But as an aside, does the Attorney General have the authority to access any case file or file in the agency?
Yes, I believe he does. He's the Attorney General.
Why does that give him the right to access any file he wants?
Well, I guess there's kind of an old saying in the legal profession that his name's on the wall. It's his agency, and he's the duly elected Attorney General. So it's his law firm. He gets to see a file if he wants to see it.
So if someone were to say that the Attorney General improperly accessed a file, would that make sense to you?
That would not compute to me.
Me neither. Can we pull up Article 4 briefly, Mr. Royal? Do you see the allegation here where it says Paxton improperly obtained access to information held by his office? Did I read that correctly?
Yes.
Let's go to Article 5 now. I'll take that down, Mr. Royal. Are you familiar with the contract with Brandon Kamek?
I am.
Okay. Did you have any involvement with hiring him?
I did not.
Did you have any involvement with drafting the contract or executing it or anything like that on the front end?
I did not.
Okay. When did your involvement with this particular contract begin? When did your familiarity with it begin?
Sometime later, after the contract had been terminated, I believe Mr. Kamek reached out to our office to inquire about payment on the contract for the outstanding invoices.
And when you say reached out to our office, does that mean he reached out to you as general counsel, someone in your division? Do you recall?
My best recollection is that it was a phone call to the general counsel division. I think he was looking for someone to talk to about it.
Do you remember a date for that phone call?
I don't.
Was that before or after you'd been promoted to general counsel?
I believe it was after.
Okay. And when were you promoted to general counsel?
During the month of November of 2020.
Okay. So sometime after your promotion in November 2020, Mr. Kamek called to inquire about payment on his contract. Is that your testimony? I just want to make sure I understand the timeline.
That's right.
Okay. You were made aware of this phone call. What did you do with that information?
I conferred with Leslie French, our chief of staff, on that, primarily because she had more awareness of these issues and what had been happening at the time. As I said before, I had no involvement with the contract. So she and I recall discussing it.
Objection, Mr. President. Question calls for hearsay, or he's about to get into hearsay at this point.
And let me clarify, please don't.
Sustained.
Yeah, thank you. Of course, I agree. Please don't relay the contents of any conversation that you had with anyone else. Don't tell me what anyone said. Again, I'm just asking, once you became aware of this request for payment, what happened next? So you said you conferred with Leslie French. Please pick up there.
My best recollection on this is that at some point, a call was made to Mr. Kamek.
Objection. Anything he could state after that is going to be hearsay.
We don't know what he's going to state next, so I don't think that's true.
Overruled.
In that case, anything next is non-responsive. May he ask another question?
You can break it down into questions.
Did you reach out to Mr. Kamek?
Yes.
What was the purpose of reaching out to Mr. Kamek?
To follow up on his inquiry.
What did you want Mr. Kamek to know when you followed up with him?
Objection, Your Honor. Hearsay.
I didn't ask for what he said. I asked for what he wanted Mr. Kamek to know in response to his inquiry.
Overruled.
The purpose of the call was to inform Mr. Kamek of how he might proceed about processing his invoices under the contract.
And what were Mr. Kamek's options to get paid at that point?
There remained work within the scope of services that had not been satisfied before we could issue payment. Specifically, the preparation of a report of his findings hadn't been completed. So what I relayed to him, and I believe this was over a voicemail, was that we couldn't make payment on the contract until that commitment had been made.
If Mr. Kamek had sent you that memo that he had contracted to provide, what would you have done?
Subject to any other clerical reason that we might have to shore up, from my view, it was a payable invoice because it was a valid contract at the time that the services were performed.
Did you ever hear back from Mr. Kamek after you advised him that if he sent you the memo, he could get paid?
I did not.
Mr. Kamek never called you?
Not to my knowledge.
And again, when was this, to the best of your recollection?
My best recollection is it would have been sometime in November or later.
I'm not sure I believe this, to be quite honest. It sounds a little disingenuous. I have to be honest.
Let's go ahead and
we
skip
just
ahead
needed to prepare a report and we would pay him. Really?
Article 7, just briefly.
Really? After the whole cease and desist thing and all that?
The Attorney
said he
General's
just didn't
office
do the
internal report regarding the events underlying this
I don't
impeachment
believe that.
proceeding?
Yes.
And broadly speaking, what is that report as you understand it?
That report is the findings of a
Just one more hoop to jump through.
Conducted internally at the Office of the Attorney General concerning the allegations that the whistleblowers raised.
Did you ever review that report?
I did.
How many times? What was the nature of your review?
No more than 3 times. I was provided a copy and asked for general feedback on the document, proposed edits, revisions, things along those lines.
Were you ever directed by anyone to make sure that the report was a sham?
No.
Were you ever directed to make sure it included false or misleading statements?
Absolutely not.
Are you aware of anyone else receiving such a direction?
Absolutely not.
What would you have done if you had identified a false or misleading statement in that report when you reviewed it?
If I had identified a false and misleading statement, I would have immediately raised that issue to the folks who were working on the report for consideration.
When was that report published?
That was August 24th, I believe, of 21.
And just to be clear, I'm looking at the text of Article 7 here. The allegation is Paxton directed employees of his office to conduct a sham investigation. Are you aware of that occurring?
I'm not aware that that occurred.
And you're one of the employees who, at least to some degree, worked on the report.
That's right.
The report was published in August 2021, you said?
That's right.
And it's been on has it been on the Attorney General's office website continuously since that time?
Yes, it has.
So, was that before or after November 8th, 2022, that this report was issued to the public?
After. Can you repeat the question?
Sorry.
I
Was
may
the
have misheard the
report made public before or after the Attorney General's election on November 8th, 2022?
Oh, I'm sorry, before.
Before. It's been on the Attorney General's office website continuously since then.
That's right.
Are you aware of whether there was reporting on the issuance of that report?
There's been extensive reporting on the issues that were discussed in that report.
When did that reporting begin, as far as you're aware?
That reporting began pretty much immediately when the whistleblowers reported General Paxton as law enforcement, and it's something we've been dealing with ever since.
And the OAG report also contains the details of those facts?
It does.
And that's been public?
Yes.
On the Attorney General's website?
Yes.
You can take that down, Mr. Roy. Let's move on
Some
to
pretty good
discussing
defenses to the
Article
report
8
itself.
a little bit. Article 8 deals with the settlement of the Brickman versus Office of Attorney General litigation. Are you generally aware of that litigation and that settlement?
Yes, I am.
As part of the agreed settlement terms in that case, are there any contingencies that must be satisfied before the settlement is fully effective?
Well, the biggest contingency would be funding for the settlement itself. I think there may have been some non-monetary considerations as well, but I think maybe the one you're asking about is the contingency of the legislature funding the requested amount.
That is the one I'm asking about. Why is that legislative appropriation of funding contingency necessary for this settlement?
Like other state agencies, the Office of the Attorney General is prohibited in the General Appropriations Act from settling a case for more than $250,000 without seeking additional funds to do that.
Does state law set out a process for seeking funding for such a settlement?
It does.
Did the Office of the Attorney General follow that process?
Yes, we did.
Do you know whether funding was appropriated?
It has not been appropriated to the state.
Has the Office of the Attorney General paid out a single dime on this settlement?
It has not.
As far as you're aware, has a single dime of taxpayer money been spent funding that settlement?
It has not.
Who decides whether that will ever happen?
At this point, ultimately, the legislature will.
The House and the Senate?
Correct.
It's up to them whether to fund it.
That's right.
The Attorney General can't force them to do that, can he?
He can only ask.
Let's pull up Texas Government Code section 554.010. Your Honor, this is just a statute. I'm not offering it as an exhibit. It's going to be up on all of the screens. Mr. Arroyo, if you could zoom in on that. And I have paper copies for the witness and the court and opposing counsel, if that would be helpful.
Now this will work.
Are you familiar with this provision in the Whistleblower Act?
Yes, I am.
Can you explain in English what the statute means?
So this is essentially a reporting requirement. There's two parts to this. When you pay out on a settlement or judgment in a Whistleblower Act case, the agency is required to essentially put together a report on that case. And following that report, the state auditor's office may initiate an audit or an investigation of basically what went into what happened with the Whistleblower Act complaint. And if the SAO initiates that investigation, then they must follow up with a report to several entities on improvements that can be made, things that can be changed to prevent this from happening again.
So let's break that down. Let's go piece by piece. If the settlement is consummated, the Attorney General's office has to do what?
It has to put together a brief memorandum describing the facts and the disposition of the suit, and it has to provide that to the state auditor's office.
Okay. The Attorney General's office has to prepare a memorandum describing the lawsuit and send it to the state auditor's office. What happens after that? What does the state auditor's office do with it?
The state auditor's office will review the report, and not later than the 90th day after that report is submitted, the SAO has the option to investigate the governmental entity or conduct an audit.
Let's just pause right there. Mm-hmm. They have the option. Has the Attorney General's office been contacted by the state auditor's office regarding this provision in connection with the Brickman versus OAG matter?
Yes.
And what's your understanding of that contact from the state auditor's office regarding this statutory audit?
We were made aware of the existence of the statute, and they just wanted to bring it to our attention in light of the settlement road that we were on to make sure that we were aware of this requirement.
The audit's coming.
That's right.
And under this statutory audit, who would have received the state auditor's report?
The Legislative Budget Board and the Legislative Audit Committee, and the governing board of the chief executive officer of the entity involved.
What would that report contain pursuant to the terms of the statute?
The SAO's report would include recommendation on changes that would be necessary to correct the problems that gave rise to the whistleblower suit.
Mr. Arroyo, could you pull up the text of Article 8, please? If I'm understanding your testimony correctly, the OAG's been notified of the statutory audit by the state auditor's office, and those findings and recommendations will be given to the legislature under the terms of the statute, correct?
That's right.
Are audits and cover-ups the same thing?
I'm sorry, could you repeat that?
Is an audit the same thing as a cover-up?
Did you say a cover-up?
A cover-up.
No, it is not. It's kind of the opposite.
If someone's trying to, conceal their wrongful acts, should they subject themselves to an audit, in your opinion, as general counsel of the Attorney General's office?
No.
Do you know whether the state auditor's office likes to conceal facts when it conducts an audit?
I do not believe that is the way they are wired.
I don't believe so either. And of course, we talked earlier, your testimony is that the allegations underlying the facts at issue in this impeachment have been reported since they happened. That's your understanding.
Correct.
You've seen reports in the media frequently about the goings on at the Attorney General's office.
That's right.
Texas Tribune seems to have a story every other day about the Attorney General's office, don't they?
There is a lot of coverage.
Do you have any personal knowledge of Ken Paxton ever forming an agreement with Nate Paul and accepting a bribe?
I have no personal knowledge of that.
And do you have personal knowledge of anything to do with Laura Olson?
I do not.
Okay. Do you have any personal knowledge of any vast criminal conspiracies involving misuse of OAG resources?
I have no such knowledge.
If there were such a conspiracy, would you still be working at the Attorney General's office?
No, I would not. I accepted promotion in this agency at a very critical time, and I assured myself and assured my wife if there were ever anything that I saw that were illegal or unethical, I would step away. And I'm still here. I'm proud of the work we do. I'm proud to serve General Paxton. I'm proud to be part of this agency.
Thank you, Austin. Pass the witness.
Not bad. Does a lot to get rid of the problems on the retaliation relating to the whistleblower's report. So there's definitely some Good stuff there for the defense on those causes of action. It was already kind of weak in the first place, and the defense is doing a good job, further cutting holes in those elements, so that's good.
Ms. Epley, your witness.
Thank you, Mr. President. Hi, Mr. Kinghorn.
Good afternoon.
Have you and I spoken before?
We are old friends now.
That's right. Is it fair to say that you have been my contact to get documents from the Office of the Attorney General?
That's right.
And that our first conversation went well, but subsequent ones got a little chillier?
That's fair.
Now, we played respectfully with one another, right? No one was rude?
That's right.
Okay. Is it also accurate, though, that right after I would have private conversations with you as an officer of the Office of the Attorney General, particular details of our conversation would show up in Ken Paxton's filings?
Objection, Your Honor. Relevance, hearsay, has nothing to do with these proceedings.
Sustained.
Mr. President, I don't know that I've ever seen a lawyer open up a bigger door in regards to the credibility and bias of a particular witness, and I would ask for a little latitude.
Your Honor, this has nothing to do with credibility and bias. She's asking about litigation discovery. That has nothing to do with
I
this.
sustain the objection. Try your question a different way.
Did you receive pressure from Chris Hilton or Judge Stone to provide you information in regards to our conversations?
Not at all, and I can answer your question more pointedly.
I'm certain that he will do that, so I don't want to be rude, but I want to make sure we move forward. Did you receive pressure in coming without a conversation?
Not at all.
Did you receive directives in regards to what position you should take?
None.
So the fact that you and I would have a conversation and it would show up in their filing the next day is completely and totally made up?
Objection, Your Honor. This is totally improper. All parties, all witnesses were free to speak to both sides. That was in the Senate rules that were adopted. And it is only fair that people producing discovery talk to both sides. They certainly talked to people we were talking to. We talked to people they were talking to. That's how the entire litigation of this impeachment has gone. This is completely improper. Nothing improper happened here. And she's not only attacking the witness's character, but my character and my colleague's character. This is completely improper.
Sustained.
To clarify, then, maybe it was the subjective use of a word. As opposed to pressure, did you receive incoming communications that inquired about our conversations?
Objection, Your Honor. Same objection, and this is hearsay.
Sustained.
Okay. You talked some about MIDI, is that correct?
About you?
About MIDI, sorry,
Sorry.
M-I-T-T-E.
MIDI, yes.
Yes, sir. You were not directly involved in
Yeah, I'm not sure that
litigation?
really makes any sense.
So mostly what you offered for us was the use of
As would be
EAM
true
or
in pretty
people's
much any
signatures
case,
to validate
a
a
witness
contract or an action.
is
correct?
free to talk
Objection, Your
to
Honor.
either
Mr. Chairman. His
side
testimony speaks for itself.
if they want.
Sustained.
What is the purpose of
And
the EAM?
they could relay what they heard from one attorney to the
purpose
other
of an
attorney, and the
EAM
other attorney
is
could use that
to
information if they
solicit
wanted.
and attain
I don't think
executive
there's
approval.
I don't think there's
of
really
an
anything
action that's being
improper about
proposed
that.
To be taken, or
It's a whole lot
or
of
an
nothing.
engagement that's being proposed within the agency.
Thank you, Mr. Kinghorn. And when you personally sign an EAM, are you signing to say, I believe this is a good idea, we should proceed? Or are you signing to confer, as general counsel, there is legal authority?
You're asking about me personally?
Yes, sir.
And I would be signing generally as to legal authority.
Okay, so when Mr. Hilton asked you and you said you were giving approval, it means consistent with your job, that's an available option that we can justify, not this is my idea, I suggest we do it.
Objection, misstates testimony.
He can answer, Your Honor, if it's within his
Overruled.
knowledge. Thank you.
I think that everyone's, depending on their role, their reasonings for going into their signatures a little different. For my role as general counsel, I'm primarily focused on whether the agency has the legal authority to take the action proposed.
And to draw an analogy then, Ryan Vassar, for example, signing Brandon Kamek's contract is approval that it's a legal justified position, not that it's the right one.
Objection, Your Honor. Assumes facts not in evidence with this witness.
Sustained.
But your approval is about legal authority, yes or no?
Yes.
Okay. I'm going to turn your attention for a moment to the PIA. Are you aware of incoming public information requests as to Ken Paxton's email, Signal, or Proton?
Typically, no. If a PI request you're referring to is directed exclusively toward the Attorney General, that's probably not a request that would come across my desk.
I think I want to be more specific. Are you personally aware of any PIA requests ever for the text messages, Signal account, or Proton of Ken Paxton?
Objection, Your Honor. Relevance.
Overruled.
There's been a great number of PIC requests concerning the Attorney General's personal communication devices. I don't remember with specificity as to the specific types of communication you're referring to.
So you're telling the Senate you do not know if a PIA has ever been requested for his texts?
If you phrase it that way, then yes, I am aware that there have been PIA requests for his text.
Are you aware of PIA requests for his Proton email?
I'm not personally aware of them, or at least do not recollect.
Are you personally aware of PIA requests for his Signal?
I'm not personally aware or don't recollect at this point.
Are you personally aware that he has those accounts?
Again, objection, Your Honor, to the relevance of this. It has nothing to do with anything this witness has testified about. It has nothing to do with anything in his personal knowledge, and nothing to do with any of the articles of impeachment.
Overruled.
I do not have any personal knowledge on the use of a Signal account. In terms of, as I have reviewed the documents in terms of producing to you through subpoena requests, I have seen that there was a Proton email account that wasn't included, I believe.
Are you familiar with the fact that either the Proton or the Signal was set up by Office of the Attorney General IT staff?
I am not familiar with that.
Do you think that you should be if it's true?
Not necessarily.
Okay. Are you aware of the fact, either through a PIA request or the subpoena authority of this Senate, we were not provided any documentation related to Signal or to Proton email for business conducted on behalf of the state of Texas by Ken Paxton?
Objection, Your Honor. Lacks foundation, lacks personal knowledge. The witness has testified that this is not within his scope and that he doesn't know anything about any of these. This is an argumentative question with no foundation.
Sustained.
Did you personally respond to our discovery requests?
Yes, I did.
Did you personally have a conversation with me about Proton email?
Objection, Your Honor. Hearsay.
I don't know what to say to that, Your Honor. We're both here.
I'm going to overrule. You can answer the question.
Thank you.
Can you restate the question for me? I'm sorry.
Did you personally have a conversation with me about Ken Paxton's Proton email?
I do remember that conversation, yes.
Do you remember telling me that you knew it existed but couldn't provide me any of those documents?
I did not say that.
You didn't tell me that you knew that there was a Proton email account, but you didn't know anything about it.
Objection, Your Honor. Asked and answered. She's attempting to impeach the witness with a conversation that she thinks she recollects. This is improper.
I'm certain I recollected, if that helps.
Overruled. You did ask, he did answer, but overruled.
Okay, so let's try this one last time. Will you tell the ladies and gentlemen of the Senate if you provided us any Proton or Signal documentation for Ken Paxton?
Sorry, can you ask it just a little bit more slowly, just the echo is...
That's fair, I speak quickly. Will you tell the ladies and gentlemen of the Senate whether you did or did not provide us any document in regards to Ken Paxton's Proton or Signal account?
We did not provide any documents related to a Proton or Signal account.
At one point during the questioning, I think what you had said was the Office of the Attorney General is Ken Paxton's law firm. Did I get that right?
Objection, misstates prior testimony.
It was in court today and a moment ago on the subject of Gross.
Overruled.
Thank you.
I've been analogizing, but yes, I did say that.
But of course, that kind of brings me to my next point. As a prosecutor, your job is to zealously advocate for the, your job is to seek a true and fair, I've forgotten my oath. As a defense attorney, your job is to zealously advocate. But as a civil attorney who works on behalf of the Office of the Attorney General, what is your oath? What are you supposed to do? What's the most important part of being a lawyer for the state of Texas?
Objection, Your Honor. Compound question.
Overruled.
I would say the most important part of my job as a public servant is to faithfully serve my principal and the people of Texas.
Do you believe your principal and the people of Texas to be different?
Yes.
Who do you think your client is, Mr. Kinghorn?
The client is the
Who is
people
my
of Texas.
what?
Who is your client?
My client
Yes.
is the Attorney General.
Would you
Ooh,
believe
is it
me if
really?
I told you that when you work for the Office of the Attorney General, you work under his authority and for him, but your client is and only ever is the state of Texas?
Objection,
I
Your
would agree
Honor.
with that.
Argumentative, contains a legal conclusion.
Sustained.
Do you believe me when I say that, or do you agree with it now as you sit here?
Objection, Your Honor. Same.
Yeah, same question. Sustained.
Yeah, the client is Texas. The principal might be the Attorney General, but the client is Texas. So
You were asked
bad
questions
answer.
about Brandon Kamek, and you relayed a conversation in which he'd called to find out about payment. Do you recall that?
I do.
And can you tell us what month and year that was?
Not with any greater specificity than what I indicated earlier.
I didn't hear you, so would you tell me again?
Sure. I believe it was after I was promoted general counsel, which would have been sometime during the month of November. But it wasn't necessarily during November. It could have been December. I don't remember exactly when it happened.
Okay. So Ryan Vassar was part of bringing you into the Office of the Attorney General, is that correct?
He was.
And Ryan Vassar was a friend of yours, correct?
Yes.
And is it fair to say that you liked and respected Ryan Vassar?
Yes.
And when he was summarily dismissed from the Office of the Attorney General, you rose to his position somewhere around November, correct?
Objection, Your Honor. Argumentative and assumes facts not in evidence before this witness. Moreover, I don't know what this line of questioning is intended to do other than improperly bolster the character of some witness who's not here. The door has not been opened to that, so that aspect of this questioning is also improper.
Overruled.
I'm sorry, could you give me the question again?
Were you promoted after Ryan Vassar was fired?
Eventually,
Yes or no?
yes.
Thank you. And it was after that that you had a conversation with Brandon Kamek, and Brandon Kamek is asking your office about payment because despite the fact that he's been employed since September,
Eric,
he's
whatever
never
can
been
be
paid.
said about
Is
the
that
Attorney
right?
General, he is not the
right.
state
And
of
as
Texas.
of November, there was no contract in place, right?
Yeah, it's definitely not the same thing. If it is the same thing, I
There
have
was a
many, many
valid
questions.
contract.
Then
in
why
place
was he
at
never
one-
paid?
At one time. By the time Mr. Kamek reached out, I believe the contract had been closed at that time. Just trying to be specific.
So what I'm asking you is, there's a secret, private contract signed only by Ken Paxton, not kept in the Office of the Attorney General at some point in this storyline, correct?
Objection, Your Honor. Argumentative, assumes facts not in evidence before this witness.
Sustained.
I don't know how else to do that. The defense's entire position is that Ken Paxton signed a contract with Brandon Kamek, correct?
Objection. This witness has been subject to the rule and doesn't necessarily, doesn't speak for the defense. It's the same question. It's argumentative. It's a sidebar. You've sustained the objection.
If I may, he was questioned at length in regards to the OAG report. Any person who's read it once or skimmed through knows that this is their position. It's not a violation of the rule. It's a question he opened.
Objection, argumentative, and lacks foundation. She hasn't laid that he knows anything about that aspect of the OAG report, and if she wants to ask that question, she can do it, but she has to lay the foundation for it and do it properly.
I'm happy to do that.
Dane, go ahead.
Did you read the Office of the Attorney General report?
I have read it, yes.
Okay, so on page 5, it reads, position taken by the Attorney General in this litigation was adverse to Nate Paul and in support of higher settlement amount to be paid by Nate Paul. Do you recall that being their position?
Objection, Your Honor. If she's reading from a document, I don't understand what it is, and I don't have it.
He's testified that he's read the Office of the Attorney General report.
I didn't understand.
He's been questioned in regards to its veracity. I intend to take him through a list of false and misleading statements to get his position and then challenge him with the testimony of the whistleblowers as allowed by the rules.
Objection overruled.
In regards to the Mitty Foundation, on page 5, it says the position taken by the Attorney General in this litigation was adverse to Nate Paul. You understand that's his being Ken Paxton's position, correct?
Objection, Your Honor. There's been no testimony about Ken Paxton's position, and there's no are we talking about the report or are we talking about Ken Paxton? I'm still confused as to what we're doing here.
Sustained.
Is the Office of the Attorney General report in question published on the AG's website?
I'm sorry, say that again.
Is the Office of the Attorney General report published on the AG website?
Yes, it is.
And do you have to have either title status, meaning Ken Paxton, or the first assistant in order to publish it?
Yes, that's a fair statement.
And therefore, every statement put onto that website is adopted and made on behalf of Ken Paxton, correct?
I believe that the report is issued by the Office of the Attorney General. Whether that extrapolates to a legal position that Ken Paxton holds pursuant to this proceeding, I'm not going to go there.
So as an officer of the court and a government agent, you're not going to honestly say that anything published on the Office of the Attorney General website is the responsibility of Ken Paxton and something he should be held accountable for? That's your position?
Objection, Your Honor. Argumentative. She's demanding that this witness make a legal conclusion that he's justified, that he's just testified that he cannot make.
He is the general. Thank you. Is your position that he cannot be held accountable for what he posts on the website?
My position is that I can't speak to the Attorney General's legal positions.
Isn't that your entire job duty?
Objection,
Let
Your
him
Honor.
answer. Let him finish his answer.
Thank you.
No, it is not. My job is to provide advice and counsel to my client, the Attorney General of Texas.
Okay. So if you had to choose between the state of Texas interest and Attorney General's interests, whose do you choose?
I do not see them in conflict.
Okay. Then back to this point. Do you or do you not, as attorney for Ken Paxton, think that he is held accountable for the items that he posts on his website?
I don't know what you mean by held accountable. That's a very vague question.
I'll help. Are you familiar with the Texas Rules of Evidence?
Somewhat. I am general counsel, not a litigator.
Do you understand what an admission by adoption is? Or an admission because it's made by a representative? Or an admission because it's made by an employee?
I'm aware of those rules.
Do you believe that those things would apply in appropriate context to Ken Paxton?
That's not something that I've researched specific to this proceeding. I don't have an answer for you on that.
I think we're all clear on you not wanting to answer this question, so I'll move along. I'm going to give you a series of statements then, and I would like for you and I to discuss them. I'm not sure if I'm here for it or not, though. This investigation revealed the OAG's intervention worked to the foundation's advantage on mediation. I'm not sure the snark fully landed. If I was telling you, or if that statement's about MIDI, and you have Ryan Bangert, Josh Godby, Darren McCarty, and Ray Chester all disagreeing with this statement, would even them disagreeing change your opinion as to it being valid?
Objection, Your Honor. Assumes facts not in evidence before this witness as to those other folks' positions. I don't have an objection to her questioning the witness about a document that I believe is in evidence, but I think in fairness he should be provided with a copy of it.
Sustained.
So earlier when Mr. Hilton asked you if you believed in the OAG report, you're not actually saying anything in it is true or not true, or that any of us should really entertain your opinion on it, right?
Objection, argumentative, misstates testimony.
Overruled.
Can you restate the question?
Your opinion on the Office of the Attorney General report being truthful is irrelevant to this proceeding because you will not address the statements within it. Is that accurate?
I don't agree with the question as you phrased it.
Okay. Then let's talk about the foreclosure letter. You went into great detail in regards to the distinctions. You relied on 418.
You think I should go down there in person and try to explain what speaking injections are?
But not Senator Hughes.
That's correct.
And so Senator Hughes's authority or name wouldn't be necessary if that was the basis of that letter, correct?
I do not believe it was necessary. That's correct.
That's a different question. If the Attorney General was relying on 418, Senator Hughes's approval would not be necessary, correct?
Woof. Woof.
If I understand yes, that's correct.
In regards to 402.042, that you do need an official requester for, correct?
You just come to try to say the most controversial hot take
and if it was an informal guidance, then no requester is needed at all.
So I suppose well done,
correct?
damn.
That would be my position, personally.
So in regards to items 1 and 2, you wouldn't need to involve Senator Hughes at all, let alone use his name to put forth an opinion that he certainly would never have approved of, right?
Objection. Assumes facts not in evidence. Moreover, she's stating a juror's opinion without following the rules.
Sustained.
Okay, last in regards to your credibility and the Attorney General's reliance on you. Is it fair to say that you represented him in a bar grievance relying on in a government filing or a court filing? And you took the position that the Attorney General was not subject to the bar rules or the state Texas ethics rules?
Objection, Your Honor. Assumes facts not in evidence.
I'm asking him, he's on the stand, it was his position.
And you're characterizing that grievance and that litigation. You're mischaracterizing it. You haven't established that any of those things are true with this witness.
That's the purpose of the questioning.
Overruled.
Did you or did you not take the position that the Attorney General of the state of Texas is not beholden to state bar ethics rules?
Objection, relevance. That doesn't have anything to do with an article of impeachment.
Overruled.
Ms. Epley, I'm not sure which, can you be more specific about what complaint you're referring to? I don't have recollection when I sit here as to specific.
Does it feel appropriate to you that you would ever, for any reason, for any purpose, indicate that the Attorney General of the state of Texas was not beholden to bar ethics rules?
I don't think that's what we said at any point.
Pass the witness.
Mr. Kinghorn, do you know if any proton mail or signal documents that would be responsive to their subpoena exist?
I do not.
Did you conduct a diligent search for those documents on behalf of the Office of the Attorney General?
I conducted a diligent search of all documents that we had in our custody and control.
Do you have an obligation to produce documents that don't exist and that aren't in your possession, custody, or control?
I do not.
I have 1 moment, Your Honor. Pass the witness, Your Honor.
Ms. Epley, are you coming back?
No, I have no further questions for Mr. Kinghorn. Thank you.
May he be excused.
May we approach on a quick housekeeping matter? It's just the admission of some records I left at the podium, frankly.
May I excuse the witness? Yes.
That's fine with us, Your Honor.
Okay. Yes, you can approach.
Yeah, that the cross wasn't particularly effective. I'm not sure if he's being evasive or not, to be honest. The only real part that I personally object to is this conclusion that the Attorney General is the client. I would sharply disagree with that, unless I misunderstood his role. So maybe I misunderstood his role, but you know, the Attorney General, it's the Attorney General of Texas. The client is Texas, so everyone at the office serves the client, which is Texas. The Attorney General may be the principal, and they're all agents of the principal, but the principal's services to the client, thus the agent's services also to the client. So, I mean, other than that, she tried to impeach him on like whether or not they ever took the position the Attorney General wasn't subject to the rules of ethics. I'm not sure I've ever heard that before. Yeah, so I'm not sure what they're referring to either. She seemed completely like flustered. That's like, yeah, I'm not sure we've ever taken that position. But if they've ever taken that position, presumably it's in some sort of documentation somewhere. But she just gives this laugh like she thought it was ridiculous and moved on. Which, you know, okay. So I don't know. He's general counsel to the AG. Okay, so maybe his client is the Attorney General. No, I don't know. I'd have to really think about it. I'd also have to look it up, like, within Texas's structure to see whether or not that's true. I know, for example, like White House counsel, the client is not the president. Or the client is not the man, it's the president. Okay, well, I've confused myself now, so let's press on. So in an actual trial, can a witness just play dumb the whole time? Witness can certainly, like, you know, fight on the question a little and make you be precise and try to, like, you can try to dance around the question a little. It's a classic thing attorneys have to deal with. So maybe he's right that the client is the Attorney General. Maybe that's the only thing that I took note of. If he's counsel to the Attorney General, well, who's signing his checks? Texas? I don't know. I'm very, very confused. But it's in context a minor distinction. So it's the only thing I really took strong exception to.
Yeah.
Yeah, that's fair, Rachel. She was talking fast. It's hard to tell what she was asking. Compound questions. Yeah, they don't believe in objection compound over here. They've certainly not raised it very much. It's not something they believe in. Austin Kinghorn filed a letter April 13th,
Members,
2023.
we will take our lunch break now until 1:30.
Let's see if we can find a copy of this letter.
Yes, and there's a short meeting before that.
I'd be interested to see what they said on the issue. So let's see if we can find what you're referring to, because I don't mind discussing it. Link in chat? There is no link in chat. I've forbidden all links. So there is no link. So you'll have to give me a description to get to it, something I can pop in Google, or give it to me on Discord. We don't allow links in the chat unless you're a mod. Multifarious, yeah. Multifarious, which is apparently the new compound. So on the State Bar of Texas website, final posted 08-18-5. Okay. 4-14. Okay, got it. No. Final posted 085-2023 -04-14. Committee on Disciplinary Rules and Referenda Proposed Changes. Public comments? Is that what the public comments on a proposed rule change? Is that what we're talking about? Okay. So they submitted a proposal on a rule change to the rules of ethics. Okay, so we can read that, I guess. Letter on page 3. Well, it's on page 6 on my PDF. His letter's on page 6 of my PDF. Let's see if this is the thing that you're referring to. 6. Okay, good. All right. So, okay, so Texas is proposing a change to the rules. And the Attorney General writes an opinion. Okay, well, King does. Austin Kinghorn. To whom it may concern, see the attached comment on proposed disciplinary rule of professional conduct 805 submitted by the Office of the Attorney General. Okay. All right, and then here's what it says. To whom it may concern. The State Bar of Texas currently exercises limited disciplinary jurisdiction over a lawyer's out-of-state conduct. Without justification, proposed disciplinary rule of conduct 805 pushes the bar's jurisdiction to its maximum possible reach while erasing all existing limitations and commentary that support of a more measured approach. Proposed rule 805 should be rejected. 805 currently provides that a Texas lawyer is subject to discipline for conduct occurring in another jurisdiction or resulting in lawyer's discipline in another jurisdiction if it's for professional misconduct under Rule 804 or the out-of-state conduct relates to certain types of out-of-state advertisements or solicitations. Proposed Rule 805 disregards these entirely, opting instead for a more expansive position. A lawyer admitted to practice in this jurisdiction is subject to disciplinary authority of the jurisdiction regardless of where the lawyer's conduct occurred. This is totally like normal. This is what? This is it? This is nothing. Similarly, current comment to Rule 3, which articulates several policy-based rationales for limitation on the out-of-state disciplinary authority, would be replaced with new comment that makes no attempt to explain the rationale of the rule. New comment 3 would instead flatly declare Texas lawyers who practice in other states remain subject to the governing authority. This isn't some special pleading for the Attorney General. This is we don't think the rule should be revised to be this broad. This is nothing to say that like the Attorney General is not subject to the rule. It's just like we don't think the rule should be this broad. This is a perfectly proper comment. There's nothing here. Proposed 805 reference to professional misconduct is the only basis for action, or replace the standard with mere reference to conduct. Additionally, implicating the validity of OAJ's jurisdictional argument in disciplinary proceedings of the bar he's brought against Paxton relating to his office's decision to file Texas v. Pennsylvania. The alteration of the rule imposes an unlikely broad standard. So the only thing he's saying is that he's saying, if I'm understanding it correctly, that he doesn't think that he violated the rule, which isn't the same thing as saying he doesn't think the rules apply to him. It's simply saying he doesn't think he violated the rule. Those are two completely different propositions, right? I'm not bound by the rule versus I didn't violate the rule. So what he's saying is that apparently the Office of the Attorney General made an argument in a disciplinary proceeding that was brought against Ken Paxton in relation to his decision to file Texas versus Pennsylvania, that he didn't violate the rule. And now they're saying, like, your change is trying to, like, make your decision, like, valid retroactively, basically. So you're trying to validate something you did because it didn't violate the rule. This isn't saying that he's not subject to the rule. It's saying he didn't violate the rule. Those are two very, very different propositions. So our question is very dumb. The office filed a motion to dismiss for the proceedings filed against Paxton. The rule limits the bar's jurisdiction on out of state. So they're not saying I'm not subject to the rule. They're saying the rule doesn't apply. Specifically, 1.06 defines professional misconduct to include attorney conduct that occurs in another jurisdiction, including before any federal court or agency, and results in disciplinaring of another attorney in another jurisdiction if it's misconduct under Texas. Thus, Rule 1.06 provides disciplinary action may be taken by another jurisdiction, must be preceded by disciplinary action brought by the Texas Bar for the same conduct. So this is just simply, I didn't violate the rules, jackasses, and your disciplinary complaint and your investigation is stupid because I didn't violate the rule. And now you're trying to change the rule because you're pissed that I didn't violate the rule, and also we don't think you should change the rule because it would be really dumb. So that's not saying I'm not subject to the rule. I didn't violate the rule. You want to change the rule, so I would have been violated the rule, and it's also stupid to change the rule to do that because it leads to all kinds of problems. So this is the basis of it. This is our basis for saying, oh, the AG thinks He's not subject to the rules. This is the basis for her scorn. So, the proposed rewrite and pending addition cannot be read in isolation from the bar's currently politically charged litigations against the Attorney General. It's well known that the bar is already attempting to establish new jurisdictional precedent by bringing disciplinary action against the elected Attorney General for exercising constitutional authority. We remain confident in these proceedings, both of which are under review by appellate courts, will ultimately be thrown out for extrajudicial abuses. So basically, the bar is acting like a bunch of fools. The bar is being a bunch of asses. And the bar is wrong. The bar is doing its level best to dramatically expand its control through the unprecedented enforcement of existing rules and through development of new rules that would drastically expand the jurisdiction. So basically, I didn't do anything wrong. You want to give yourselves uber new authority, and it creates all kinds of problems. So that's nothing like what she asked. How long have I lived in Texas? 3 years now. Yeah. So none of those things. And then other people have comments about various rules. So other people wrote opinions about their thoughts about whether the rules should be changed or not. So, whatever. Not quite Texan. Well, the 14th Amendment says I'm a citizen of Texas, so I'll take that. I do live in Austin, yes. Do I like board gaming? Somewhat. Yes. Not the what I once wrote, and I worked on a committee that was revising a rule of ethics, and that was early in my law career. I was working on a committee to revise some rule, and the rule changed the way I thought it should have been revised. So, I got involved in the process and, changed the rule. So, as one does. How's Austin these days? Depends who you ask. So that's where we're sitting on all this. So anyways, they've done a pretty good job on breaking up the idea that the report itself was like fake or fictitious or disingenuous or stuff. So they did a pretty good job breaking apart that element, that element of the charge. But yeah. So I think his answer was correct. Now it's like, we never took the position he shouldn't be subject to the rules of ethics. We took the position that he didn't violate the rules of ethics, and your change is dumb, and it's political in its nature, and also gives the bar massive power, and we see what you're doing, and your decision to charge him in the first place was political in nature. But, that's completely different. All right, so they're on break till 1. So I get 20 minutes of break. Okay, well, I will end the stream for now, and we will be back at 1. I may not be on camera when we come back because Uncivil needs a break. But 1:15, excellent. I could use the extra 15 minutes. Uncivil needs a break, so I'm going to take a break, and we will be back later. And just a friendly reminder, we're going to have to end the stream at about 6 or 6:15. So, we have a hard stop today, so just a friendly reminder. So I'll be back later. I've been Uncivil Law. Until later, my friends. I hope all is well. Cheers, my friends, and goodbye.